Further hearing includes Pitman and Hernandez and the State.
Well, just to summarise the additional materials, there should now be a volume 10 available electronically of the additional materials that were handed up yesterday. Yes, it's got the 1946 ordinance, the Mental Health Act 1975, the Atkin Committee, and Peters, Herbert and Mitcham, which were referred to. And we will be providing, if any of the board would wish to have that in hard copy, we can provide that, but not immediately. Those are the materials that were handed up, as it were, piecemeal yesterday or referred to. There is also on the board's desk a short chronology of the historical developments that we've put in the case. There's nothing new there, it's simply so that you can see it in diagrammatic form. Then there is a note on felony murder in response to the questions asked by my Lord Hughes, and there is also a note in answer to some of the questions raised by my lady and your lordships yesterday. So those are the additional materials.
Thank you very much indeed, Mr. Fitzgerald. Thank you. Yes, Mr. Knox.
My lady, my lords, I'll deal first with conviction. My lady, my lords, there are 2 points. The first, the admissibility of the confession. Second, the Jody point. Dealing first with the confession, there were 2 issues raised at the voir dire. First, did Mr. Pitman make the statement which he signed, or was he induced to sign it by being tricked into placing his signatures on it by promises he would go home if he did so? The second issue was the signatures to the confession unfairly obtained because he had not been cautioned or told of his right to see a lawyer? Those were the issues actually before the judge at the time. The judge found first that the appellant did make the statement and did so voluntarily, and you can see that right at the end of the submissions in reply at page 1079. So he makes a finding of voluntariness. Perhaps I should just show you that. It's at the end of the submissions in reply to prosecution case on conviction. 1079.
1079 of the...
Well, the electronic record. It's page 1079, and I've got it in hard copy form at the end of the submissions in reply to prosecution case on conviction.
Yes.
I'm not sure that... Is it in the original record or in the full record of the voir dire that we got yesterday?
Yesterday.
It's in the one behind Mr.
Yes.
Fitzgerald's notes, submissions in reply to prosecution case.
1079.
Last page.
Yep.
Well, in my case, it's 3 pages from the end, although by the numbering would suggest it was the last page.
Oh, really?
But I do have page 1079, and it does have the statement.
And you can see the ruling.
The ruling, rather.
Oh.
As
You can see the ruling. Court is satisfied beyond all reasonable doubt that the statement was given voluntarily and that there was no breach of any of the protected procedural provisions of the Constitution, and it will be admitted evidence on the general issue, and I so rule. And a little earlier on, if I can just take you back to page 1074, you can see the judge's interventions in the course of Defence Counsel's submissions. You can pick it up at 1074, about at line 42. The court asks, did he ask for any lawyer? Mr. Sturge, he didn't ask. How old was he at the time? 22. Mr. Sturge, he was 22 at the time, my lord. From his evidence, he wasn't told anything about that. The court, I'm satisfied on the evidence that he had sufficient advice to elect to say, look, I need to have a lawyer here, right? Call my aunt, call my mother, call whoever it is at this time, and he did nothing about that. That would suggest to me that he didn't want to have anyone there. It would suggest to me that he didn't want to have Mr. Merritt or Mr. Sturge or Hudson Phillips or whoever present. He wanted to say what he wanted to say in the absence of counsel because he had the advice that he could have a lawyer, and he did nothing about it. And then he goes on in another passage in similar vein, at page 1077, halfway down the page, line 20, Court, Mr. Sturge, I'm prepared to make the finding of fact that when the statement had been given at that time, the accused was conscious of his constitutional right and was made aware of it, his right to counsel, and he did not elect to have counsel present, so that is a non-factor. In other words, I'm not impressed by your argument. There's no correlation between the two. So that was those were the judge's findings on the evidence he had before him. Now, the question then arises, well, does the new evidence really add anything on either of these two issues, the issue of voluntariness or on the issue of fairness? And in my submission, the answer is no. And my lady, my lords, the starting point is what, in fact, is the effect of the new evidence. And for that, my lady, one has to go to the Court of Appeal's conclusions, and one can pick that up in as it were, the very first record that came in, at page 343. Paragraph 16, Pitman was late in achieving some developmental milestones as a child. This was attributed, at least in part, to the fact he was said to have fallen from a significant height as a baby and landed on his head. Pausing there for a moment, that was the evidence of Miss Pitman's guilt at the voir dire, so this is nothing new. He never advanced beyond primary school and was described by one of his teachers as a slow learner, quiet and withdrawn, with difficulty in responding to questions and expressing himself. Again, that was in the voir dire from Father de Vitoy. And then, from all the evidence available, this is now obviously including the new evidence, it seems that even as an adult, it is not easy to have a conversation with him. He will probably say little unless prompted and takes his time to respond. So that's the first thing the Court of Appeal finds. Then one goes to page 348, and I'm now just going to take you to those references in the Court of Appeal's judgment where they effectively say, we formed very much the same view from the transcript of the voir dire as Mr. Sturge did. So the first reference for that is page 348, paragraph 33, under the heading Mr. Sturge. In his affidavit, he deposed to the fact that he had read Dr. Brannan's report and wished to comment on her conclusions. He had interacted with Mr. Pitman on a daily basis for nearly 2 months, and although he couldn't read, he showed a grasp of his right to remain silent and its implications. He chose to testify at the voir dire and denied the statement because he appreciated the need to have it excluded. He also understood the difference between the voir dire and the trial. He gave fluent and coherent evidence and was not unreliable under pressure, but stood up well to cross-examination. He displayed sharpness in response and capacity to comprehend the apparent attempts by the prosecutor to challenge his veracity. He even showed wit on occasion, was quick to point out without assistance when he needed clarification of the questions. His answers were largely consistent. And then the important point, suffice it to say at this stage, our review of the transcript left us with the same impressions as Mr. Sturge. And again, page 355, paragraph 61. And my lady, I respectfully submit, one has some sympathy with the Court of Appeal's comment in paragraph 61. Those of us who've read quite a few of these types of transcript. Indeed, a striking feature of the transcript of his evidence is it is indistinguishable from what is produced every day in our courts from the average, quote, normal witness. We have no reason, therefore, to doubt Mr. Sturge's evidence about how he handled himself in court or in the giving of instructions. So again, an endorsement of Mr. Sturge. And then finally, paragraphs 64 and 65. He did, however, this is the court's observations from the transcript. He did, however, have very definite ideas about what his evidence and his defence were, as opposed to what others might be suggesting. A very telling passage occurs at 11:85 when he recounts his meeting with the JP. He told me that if I give him a statement, and I tell him I'm not giving a statement, but them just putting words in their own thinking and saying that I wasn't in a fit state of mind to give a statement. I never say it like that. I just say I'm not giving a statement. One can readily understand why Mr. Sturge abandoned the idea of pursuing a defence of diminished responsibility. Counsel was in all likelihood making a reasonable tactical decision based on his interaction with the client. Can hardly be criticised for not pursuing it. So generally, the Court of Appeal is endorsing Mr. Sturge's evidence about Mr. Pitman. By contrast, it rejected, in all material respects, it seems, the evidence of the defence experts, which was adduced before the Court of Appeal. One can start at page 351, paragraph 5. And the first point it makes, and it's obviously a fairly stinging point, in this particular case, two experts, one of whom had never examined Pitman, came... Sorry.
I'm sorry. You said 351, unless I got...
Oh, 41, forgive me. 41.
That sounds more like it, yes.
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 In this particular case, two experts, one of whom never examined Pitman, came to such a conclusion, that is, he didn't have the ability to stand trial and so forth. In striking contrast to the observations of the trial judge in this court, the record of the trial which was available and apparently selectively referenced before the Privy Council, and the evidence of his own trial counsel, who it seemed felt compelled to go on affidavit in order to present us with a more accurate view of the circumstances surrounding the trial. And then page 342, paragraph 11, the evidence of the appellant's experts was weighed carefully against the competing evidence from the State and questions in response to the appellant at trial. The latter record proved to be helpful as it gave an objective basis for assessing the appellant's level of understanding. The weight given to the expert evidence on behalf of the appellant was influenced by the fact his experts had not seen the transcript before rendering their opinions and by their reaction and cross-examination when confronted with it. And then page 353, paragraph 51, speaking of Dr. Bramman, I think it's Bramman with an N, not an N. It's repeatedly spelled with an N in the Court of Appeal's judgment. Paragraph 51. We have already alluded earlier to the fact that the weight of Dr. Bramman's evidence is affected by the fact that her conclusions were arrived at while she was ignorant of the fact that Pitman had given evidence in the voir dire. This was one instance in which the demeanour of a witness also impacted on her credibility. She was visibly discomfited upon being confronted with the transcript, although she stoutly defended her original conclusion. And then it goes on to say that part of her evidence was slightly equivocal. Then, in similar vein, page 354, paragraph 55. In summary, therefore, we were left with the fact that all we know for sure is that his IQ was below 70, i.e. subnormal, and although from a layman's perspective a score of 67 might seem very different to one of 52, persons in the 50 to 70 range are generally lumped into a single category. Individual characteristics and abilities can vary, and the precise extent to which test configurations and cultural factors might affect the aggregate score is unknown. It's for that reason that Dr. Bramman, was directed to the voir dire, and so forth. And then, finally, now, of course, Professor Kopelman, his report essentially depended upon Dr. Bramman, because he hadn't, in fact, seen certain scenes and the appellant. But finally, page 357, you can see what the court does conclude, paragraph 68, in relation to the expert evidence. It's not necessary to go through the transcript line by line to get the flavour of his evidence. That's Pitman's evidence. The court has undertaken a meticulous examination of his evidence, bearing in mind the caution necessitated by the unchallenged fact that he suffers from some degree of mental retardation. We reject Dr. Bramman's evidence of it and her conclusions concerning the impact of his mental impairment on the issues we've been asked to consider. On the other hand, we find Dr. Maharaj's evidence to be more persuasive in that regard. We've also taken into consideration all the circumstances, including in particular the evidence of Mr. Sturge, And if you go to Mr. Maharaj, you can see that at page 56. So one can take what you see at page 56 as essentially the court's conclusion on Mr. Pitman's mental capacity or intellectual capacity. And Mr. Maharaj was the state psychiatrist who interviewed the appellant, I think in 2009, 30th of March 2009.
Sorry, which paragraph?
Where?
It begins at page 55.
Page 55.
Page 55. This is the report. And he administers what is called the Wechsler Adult Intelligence Scale Revised Test 1. My lady, I don't think we need to get into the different tests that we used.
Well, do we not? Was criticism not made of him for not administering the up-to-date test?
Well, I think it was said that was put to him in cross-examination. The court don't really accept that criticism.
Well, did they reject it or deal with it?
No, not really. I think they said, well, there was a difference between the two tests. He doesn't use the most up-to-date test. The trouble is, of course, both tests are not based specifically on Trinidadian people at all. I mean, that was one of the problems. How do you take into account the fact that you're dealing with a Trinidadian and there's the problem of cultural bias? But my Lord, the simple
It
answer...
usually works the other way round, that people score lower on these tests, the standardised tests, because of cultural
Exactly.
rather
Yes.
than higher than they should.
Yes.
I'm not sure that that applies to these tests, the Wechsler, rather than the old Stanford ones, Stanford Binet one.
Well, as I recall the evidence, it was essentially that whichever test you're applying, you have to take into account the fact that you're dealing with a Trinidadian, and the tests are not specifically designed for Trinidadians, so the Trinidadian score might come out lower. The score of the average Trinidadian might come out rather lower than if the test was specifically designed for a Trinidadian. But in any event, this is the evidence that's accepted. In one sense, the question of the score isn't so important. What really matters is the degree of abnormality. And what Dr. Maharaj found is in page 56, test results. Performance on the VICE R, a test of general intelligence, places the subject in the range of mild mental subnormality. FIQ equals 67 against an average of 90 to 109. Scores on both the verbal and performance scales were below average. There was no significant difference between verbal and performance scores and no intratest scatter. This means that on all subtests, the subject was weak in all areas tested. And then he goes on over the page. On the BIP bender, drawings were generally immaturely executed. They were well placed on the drawing sheet. Size was constant. The protocol was score-based, level 1, class A, no evidence of organic brain disorder. The Wechsler Memory Scale Form 1 revealed that the subject was well orientated to time, place and person. Concentration recall of familiar material was not a challenge for him. The recall of material presented for the first time, as in the reading of a short story, presented a difficulty to him. His ability to learn new material after rehearsal is not impaired. The reproduction of figures from visual stimuli does not reveal any abnormality. And then on the Chernal graded word test, the subject attained a reading age of 7, while on the Aycliffe word spelling test, his spelling age was 6 and 6 months. Overall impression, clinical interview and psychological assessment of Mr. Pitman reveals a person functioning at the level of mild subnormality, underdeveloped reading and spelling skills. No evidence of organicity from the assessment. Mr. Pitman is functioning at a level where he can easily be influenced and misled by unscrupulous characters. He can, however, maintain himself in a job that does not require a higher level of cognitive skills.
If a person of his ability were interviewed alone in this jurisdiction and convicted solely on the evidence of his confession, and he hadn't had the benefit of legal advice or the presence of an appropriate adult, would his conviction be regarded as safe?
Well, if there'd been a justice of the peace there, of course it wouldn't happen here, but why not? My Lord, I submit the presence of a justice of the peace who speaks to him in private twice before he eventually gives his statement is a very important point.
A justice of the peace to whom he had never been introduced previously.
Yes. But my Lord, in my respectful submission, even if in this jurisdiction that would be regarded as an unfair confession. That doesn't, in my submission, affect what the result should be in Trinidad. We're talking now in terms of what the position was in Trinidad in 2001.
Well, why do you make that submission?
Well, because the judge's rules were the relevant rules which the police had to follow, and they did. They did everything they were supposed to do in accordance with the law which applied to them.
Yes, but we're talking about the safety of the conviction.
Well, we're not in my respectful submission. We're talking about the fairness of admitting the statement.
No, the premise of my question
Yes.
to you was on
I
the
see,
safety of the
yes.
conviction.
Well, my Lord, I've anticipated my answer, if I may. That is, if the confession is, if it was fair to admit the confession, and the confession plainly was made voluntarily, I'll come to that in a moment, then the conviction is safe.
Well, the premise of the question put to you was a man with this kind of mental condition interviewed alone in this country. If that happened in this country, what would be the position in relation to the code?
My Lord, I can't answer that question.
Well, there'd be an apparently deliberate breach of the code of practice, wouldn't there?
Well, if it was deliberate. I mean, in this case, of course, in the Pitman's case, he was advised of his right to see a lawyer, and he said, I don't want to have one.
Yes, I'm just trying to see what
Yes.
the position in this country would be, since that was the question that you were asked.
Yes.
In this country, there would, on the face of it, be a breach of the code.
Yes, that would follow.
Which is a factor,
Yes.
although not a determinative factor, in exercising the Section 78 discretion about admission.
Yes.
Yes? Right. In this case, the evidence of the JP was, unless I've misunderstood it, that he had been introduced to the defendant. He'd then asked the police officers to leave.
Yes. The first time, yes.
Well, it happened twice. But
Yes,
the first time, he'd asked the defendant whether he had been well treated, effectively,
Yes.
whether anybody had hit him, whether there had been any promises made,
Yes.
how long he'd been there, whether he'd had anything to eat,
Yes.
and importantly, whether he wanted to make a statement. And the answer to all the questions was satisfactory, and the answer to the last question was no, he didn't, at that stage.
The first time round.
That's
yes.
right.
Yes.
Then,
Fit mental state or something.
then, at some later stage, he went through the same process again,
Yes.
receiving this time the answer that he did want to make a statement.
Yes.
Now, you can speculate about how that came about, but that's what the JP said.
Yes.
Did the JP then leave, or did he stay and, as it were, take or listen or watch the statement delivered?
So I speak of recollection. I think he stays while the statement is given.
He absolutely...
And then he authenticates it.
He absolutely did.
Yes.
He heard, he says, the defendant speak it and watched the policewoman write it down.
Yes.
That's what he said, anyway.
Could you just give us the reference to that? James, I've failed to make a note of it. The reference to the JP's evidence.
Yes. It's in the document I was talking about before. This is the copy of the full transcript attached to the appellant's submissions in reply on conviction. And it begins, I might be saying, forgive me, I'm just digging up the reference, page 1011. The examination in chief begins at page 1011.
There are two-page numbers on it.
850, forgive me,
850
850.
and 1011.
Yes, I apologise. 850, and it continues, the examination chief continues at 853, and then he's cross-examined.
He's cross-examined at some little length.
He is.
And effectively, although the progress of the cross-examination is not altogether satisfactory, what's being put to him is that he's not telling the truth.
Yes, yes. Now, the judge obviously accepted that he was telling the truth, so we know that.
Yeah.
But in answer to my Lord Kerr's question, my submission, there would be an issue about a breach of pace. So there would be the judge, as well, the judge, the Court of Appeal, would have to decide whether it was fair to admit the statement. in all the circumstances, but in my submission the answer would be, if this had happened in England, well, it's not unfair to admit the statement.
I'm sorry?
It's not unfair to admit the statement, and therefore it would be admitted. And it certainly couldn't be said in my respectful submission that any judge in England would knock the statement out on the basis of unfairness. I'll come to voluntariness, if I may, in a moment. My lady, can I make a preliminary point? And it's this. In one sense, the new evidence hardly takes matters any further than they were anyway on the voir dire. I mean, it was known, a point was made in the voir dire that the appellant was very slow. And one asks rhetorically, well, look, supposing you had Dr. Maharaj's evidence there, would that seriously have made any difference to the court's appreciation? I'm leaving on one side the pace point, if I may, for the moment. But I do respectfully submit it would not have taken matters much further if you'd had Dr. Maharaj's assessment. And I say that because the question of the lack of intelligence and lack of schooling and so forth was well before the court. That came both from Miss Pitman Gilks, his aunt, but also from Father de Vautoy, who basically said he is slow, although he also said he does seem quite intelligent, but he's slow. And he was called for precisely that purpose. I can give you the reference to Dr. Vautoy's evidence, which comes first to begin. Father de Vautoy's evidence, which starts at page 1036, and it continues to examination in chief, at least, continues until 1039.
What sort of numbers are you using?
The right ones.
The electronic ones?
Not the ones at the right hand.
You mean the correct ones?
Yes. No, I mean the correct ones, yes.
Yes.
It continues, sorry, I said the examination chief continues to 1041, but the material parts, you can see at the foot of 1037, beginning at line 34, that's 27, it says when he first saw him. Line 27 to line 50, going over the page. And then halfway down the page 1038, line 18.
How to flatter your judge, yes?
Yes. He says, he finishes at line 26, 27, the witness, well, slow, definitely, yes, I got that feeling from relating with him. The court, yes, but what's the edge you have over me, for example, in making that assessment? That's what I want to know. The witness says, that's a hard one. I'm accustomed to dealing with people, it's true. Whether I'm superior to you, that's a hard one to answer. And then, by Mr. Sturge, in your 45 years, would you have interacted with persons who were normal? Yes. Persons who were subnormal? Very much so, that would be true. Then he's asked about his experience about that. And then over the page, line 8. Yes, Father, now having seen him, did anything strike you about him? Apart from the fact of his slowness, is it? Yes. No, he seemed to me to be a bright young person that I could relate with, so I would say that was good, yes. Anything strike you about his slowness? Well, I would say that if we had a discussion of something, that is how he will come across, as slow. Yes, I'm not sure he'll be able to follow everything you know. I'm sorry. I'm saying if we had a discussion about something, I would imagine that the slowness will come out, you know. So you're saying he's not intelligent? No, I wouldn't say that. No, he's intelligent, but slow. Very slow? Yes. What's the difference? Then he ventures a difference. 31 to 36. And then going to page 1041, at line 16, question, can you tell us from your appreciation, having refreshed your memory, can you tell us about your assessment about what struck you, about how little he knew about life in general? Answer, well, I suppose I mean by that how he would relate to people in general. All right, so he was struck by how little he knew about life in general. answer. That's right. The court, good one, Mr. Sturge. I imagine it's a reference to a slightly leading question, but the point is made. But the reason I show you this is the issue is well before the judge, and you can see that from his comments, which I have in a different part of the transcript, although I suspect they must be in this part too, where, may I be forgiven for going to my original reference, there is a part of the transcript which I have a different reference to. But the judge, perhaps I can just give you the gist. The judge says, well, we all know he didn't qualify from school, and that he's rather slow. The references I have are in the original supplementary record of the proceedings at 435. And it's in the middle of this cross-examination. 435, lines 38 to 43. And this is in the cross-examination of the appellant, and the judge intervenes. Mr. Sturge gets up at line 38 to intervene in the cross-examiner's questions. My lord, he wants an opportunity to explain. He says he was explaining he was cut across. Can he be given the opportunity to explain? The court, why not? If that's how he is to give his answer. Remember, this is someone who said that he didn't pass the common entrance. I see. So if he needs to explain to give an answer, then fair is fair. He must be given the opportunity. And then over a few pages to page 447, at lines 24 to 33, Mr. Sturge again intervenes. My lord, it's clear that the homicide officer is one office. It's not clear to him whether in the cubicle, whether in the cubicles is room or present, the office is present. That's not clear to him. Mr. Busby, knowing that he has not passed common entrance, knowing that he's not as brilliant as Mr. Busby, I don't think he's been very patient. But the reason I draw your attention to this is it was one of the issues before the judge was, in any event, the lack of intelligence and the lack of educational qualifications. So that's why I say it's difficult to see how Dr. Maharaj's evidence would really have made the judge come to a different view, or indeed any reasonable judge. Can I deal specifically with the pace point? First, and I submit it is important, this, pace was not applicable in Trinidad, obviously, in 2001, or indeed 2003. 2001 is material time. That's when the confession was taken. And there's nothing in the judge's rules which says that an adult must be present in such circumstances. I should just show you what the judge's rules do say, and one can find the judge's rules in tab 2 of the bundle of authorities. I think at page...
Bundle 2.
Sorry, bundle 2. And they begin at page 403. You can see the preamble on page 404. The relevant part of the preamble is paragraphs 4 and 5. The rules which have been made by the judges as a guide to police officers conducting investigations should constantly be borne in mind, as should the general principles which judges have set out before the rules. But in addition to complying with the rules, interrogating officers should always try to be fair to the person who's being questioned, and scrupulously avoid any method which could be regarded as in any way unfair or oppressive. So that's the general principle. And in Appendix B, there's a statement of guidance for interrogating officers about various procedural points which may arise in the course of interrogation and taking of statements. And then there are a number of specific provisions. I don't think I need to take you to these, but I should take you to what you see on page 411. Now, this is the closest one gets to what you might, in the judge's rules, to something which might at least notionally help the appellant, and it's in paragraph 4, interrogation of children and young persons. As far as practicable, children, whether suspected of an offence or not, should only be interviewed in the presence of a parent or guardian, or in the absence of some person who is not a police officer and of the same sex as the child. The child or young person should not be arrested nor even interviewed at school if such action can possibly be avoided. When it's found essential to conduct the interview at school, this should be done with the consent of the presence of the head teacher. But there's no provision, for instance, which deals with interrogation of people who are appear to be intellectually disabled or not that bright. So I do respectfully submit it is important, as a starting point, that there is no breach of the judge's rules, and those are the rules which govern the police officers. And on the face of it, I do respectfully submit there's no reason for saying, were it not for what we see in Pace, no reason for saying that this was an unfair interview, given the presence of the Justice of the Peace, both the first time round when he speaks to the appellant, and then the second time when he speaks in private to the appellant, and then also witnesses the statement.
What would have been the Pace breach had it been in this jurisdiction?
Well, as I understand it, the absence of the absence of the presence of an adult. I think the material we saw yesterday,
right.
There would have to be an adult. If you're an intellectually or mentally disordered person, I think there has to be the presence of an adult who is able to assist.
Yeah.
And as I understand it, the point that's taken against me is, well, look, a Justice of the Peace is not there to assist. Sure. He's there to hold the ring.
But was he advised of his rights to have a lawyer?
Oh, yes.
Yes. So there's not. Yeah. So it's not Pace itself. It's the provisions relating to appropriate adult in the case of a young person or a person with a disability.
Yes.
It's in the code of practice, Mr. Knox, isn't it? It's in the code of practice.
Yeah.
Yes, about the adult. We saw it yesterday, I believe. Yes.
And the status of the code of practice is that it is a relevant factor to Section 78 discretion.
Yeah.
Yes.
Yes. Thank you.
But in my submission, and this is an important point, we are not talking about a case in Trinidad where the judge's rules were in force in 2001 and subsequently Pace has been incorporated in Trinidad, so one can, as it were, in deciding what is fair in Trinidad, look at Pace. In my submission, that is a fallacious line of reasoning to say that because in England we've adopted Pace, it follows that in assessing fairness in Trinidad, what the court should also take into account Pace. I submit that's not right. It might have been right had Trinidad itself decided that this was a proper way of, as we're ensuring fairness. But without Trinidad having done so, in my submission, it would not be right for this court to take what you might call a sort of, well, we know better in this jurisdiction than they do in Trinidad. But in any event, my lady, even if one is to take into account what you might call the specific provisions in Pace, in my submission, they don't lead to the conclusion that this confession would have to be excluded. That's what it really comes down to, on the basis of unfairness.
Well, fairness is to be determined as a matter of geography then, is it?
No, but one of the difficulties is, of course, that that there is a different system in Trinidad. I mean, for instance, the requirement for the presence of the JP. One can't just say, well, look, what you've got to do is ignore their system and assume they should have had our system.
No, I don't think anyone's suggesting that.
No.
Yeah.
But the underlying question is still
There's no room for
fairness.
deep scepticism of the role of the JP, is what you're saying.
Sorry?
There's no room for deep scepticism about the true role of the JP.
No.
Well, even, of course, accepting everything that you say, are we allowed to take into account the reasons why Pace is as it is?
Yes.
And we know what those reasons are. We know that some people, and there was one particularly startling case, with intellectual disabilities, did make confessions which were later shown to be totally wrong.
Yes.
And it was something of a scandal, and the reason, therefore, for introducing special provisions in the Pace Code of Practice about the interrogation of such people.
Well,
Are we allowed to take all that into account?
well,
Common knowledge within this country, I would have thought.
well, you might say human experience shows, I would accept this much, human experience shows that people in custody, with people with low IQs, or there are certain types of vulnerable people who are in custody who might make confessions which in fact are completely untrue because they feel the need to please their oppressor, something like that. One can see that human nature is like that, and therefore, if there are not certain protections in place, then one might have a doubt, no more, as to the fairness of the confession. One might need to be very careful in deciding whether to admit it. I'm being sensible. You say, well, I need to be pretty careful about this. But in other words, one might say, but possibly with the new material, one might possibly, indeed I would have submitted on the old material, and this is part of the problem, one might say, well, look, one particular question the judge should have, as were considered, was the fact that he didn't have, that the appellant did not even have with him an appropriate adult to help him. Therefore, I need to be a little bit more sceptical, if you like, as to whether this was indeed a confession he made. The difficulty in this case, my lady, is that there's no doubt, in my respect, I'll come to the evidence in a minute, there's no doubt he did sign the statement, and it couldn't just have been a pre-prepared statement which he was just stuck his signature onto at the end. One can actually see that from the statement. And so this is a case where there is very strong grounds for believing that this was a statement he did actually make, as the police say, especially as the justice of the peace witnesses it. So the concern that one has about, as it were, a vulnerable person making a confession to please his oppressor is not, in my submission, present in this case. And may I add also, bearing in mind particularly what the Court of Appeal found about the appellant. And they make the point that he's not actually the sort of person who just caves in at the first opportunity. He's actually got a mind of his own. Supposing the evidence had been slightly different, supposing the Court of Appeal had accepted that there's a man who's terribly impressionable and will say virtually anything to get out of trouble. I can see in those circumstances one might say, well, it is a little bit concerning.
Just a little bit.
You must allow me. But one would say it's concerning. But that's not the state of the evidence about the appellant.
Yes, exactly.
And that's not the state of the findings about him. So that's why I submit that although the question of fairness, one might say, it arises because of the absence of an appropriate adult, it is not such as, in my submission, to require the court say, I'm not satisfied with the fairness of this confession. Or indeed the reliability. Can I deal with the actual confession itself? Can I just show you, it's the point I did want to take you to. The confession itself, I think, appears in the supplementary record at page 417. And the reason I take you to this is because the appellant's case was that this was, and had to be, this was just pre-prepared, and he was just asked to stick his signature onto it. On the basis of a promise that if he did so, he'd go home. Words to that effect. And can I just start from the top? This is an important point I want to draw your attention to. Fairly simple point. It gives his name, top of page 417, male, 22 years, occupation, construction worker. I mean, this is a man who can hold down a job. And the people who are present, there's two police officers. Investigating officer taking statement is WPC Phillips. There's another officer, Sergeant Corbett, and then JP Motley de Piazza. This is right at the top. And then you see the introduction. I wish to make a statement. I want someone to write down what I say, and so forth. The usual wording. And then it's signed by him, Lester Pitman, 19th of December. So he signed it there. And also the Justice of the Peace has signed it, and the two police officers signed it. And then he starts the confession. I'll come to the words later. And then you'll see at the foot of the page, the same four people have signed the statement, and the Justice of the Peace has actually put his stamp on it as well. And goes to page 418. Foot of the page, same position. Again, the Justice of the Peace is there. Page 419, and one's beginning to see it's quite a detailed statement. Page 419, again, the same position. Page 420, an important point arises from 420, and that is 5 lines down. I should perhaps start at 419. A question is asked at the foot of page 419. Question, when you say you went by a house, where was that house? And then answer, bit of overwriting, house in Cascade is a good-sized house, and that was his family house. Question, you said he tied them up. Do you know what he tied them up with? Answer to question, some kind of black wire. Question, we spoke about a blade. Can you describe it? Answer, short cutlass with a fine glass handle, like my hand. Accused points from elbow to wrist. And then he signs that bit there. Now, of course, the notion this is a pre-prepared statement, which he just so happens to come along to, and as with signs, it's difficult to see how he could have signed in the middle of the page like that. I mean, this, in my submission, overwhelmingly suggests.
This is rather a blast from the past for some of us, Mr. Knox. It wasn't unknown, sadly, for confessions to be fabricated in this country and for signatures to appear in very much the same way as this.
Well, because they knew that was the way to do it.
I'm afraid that's right. On the other hand, one of the things one did used to look for was information which wouldn't have been available to the police. Had the weapon been recovered?
I can't off the top of my head answer that question, but no doubt.
Because nobody survived from the house to describe it, did they?
No. I can't remember whether he said it was thrown away actually later on, but I don't know. But in any event, you do have the full thing.
You've got the point that there's a question and answer.
You've got a question and answer.
It's either been very carefully prefabricated,
very carefully,
or it happened.
And also the Justice of the Peace is in on it.
Yes, that's right.
I mean, he's in on this sort of conspiracy. I mean, it does get progressively more unlikely.
But that's a fact, yes. All right, well, that's for the judge.
And then again, the foot of the page, you'll see the signatures. And then
So who was doing the writing out?
Writing out at this point, I understand, is being done by one of the police officers, and I don't know if one can actually tell from the handwriting. I can't off the top of my head recall what the evidence was as to whose handwriting.
I think the evidence was that it was Miss Phillips, but that may be bad recollection.
It looks as if it might be. In fact, just look at the handwriting.
Sounds very likely, doesn't it? Yes.
Yeah. You can see her handwriting, which does look exactly like the handwriting which most of the statement's taken. But then it continues at the end. The undersigned, I think, Justice of the Peace.
Which page?
At the end of page 420, you can see a section which appears to be recorded in the hand of the Justice of the Peace, a long section. The undersigned Justice of the Peace, residing at and so on, gives his address, going over to page 41. Today, received a telephone call, I think, at 9:15 p.m. today from the Homicide Bureau. As a result of that call, I was unable, I think, to, quite sure, immediately, whether it's arrive or
Proceed, I think you mean.
Proceed immediately to the Bureau. But eventually, I got there at 2:25 p.m., where I met Sergeant Dick, and he continues to say what happened, and he continues to, and he sets out questions that he himself had asked of the appellant.
It was Miss Phillips, page 822, 823.
Yes.
Yeah.
And this goes on for some time, 422, 423. So, if one can, as I suspect one can, place reliance on the fact that you do have an independent officer of the court there who writes all this out, one can, in my submission, be reasonably sure that there was no skullduggery in obtaining this statement.
That includes, does it, the answer about, at the first meeting of the JP and Mr. Pitman, his asserted answer that he didn't want to make a statement because he wasn't in a fit state.
Well,
That's at page 422, look.
Yes.
I hadn't appreciated that. It's all written out, is it?
Exactly, about 10 lines down on 422.
So this is an account of the first meeting, is it?
Yes. In other words, what he is doing, he's saying how he's reciting the previous history.
Well, he recites both meetings. in
Yes.
fact,
Yes.
That's right.
And where does the second meeting start? It's not terribly easy to read.
No.
Halfway down page 422, I think.
Yes.
At this stage, I was called to the adjoining office to
Yes. At
authenticate
this
the
stage,
statement.
yes.
I'm sorry, no, it's the next paragraph.
Well, this is very difficult to make sense of, isn't it? What he says on that page.
He made it clear in his evidence, the middle part about being called to an adjoining office to authenticate a statement, was
Yes.
to authenticate a statement made by a witness.
Yes.
Then he was called back, he said,
Yes.
to deal with Pitman again, and you
Yeah.
get that just over halfway down 422 after the statement.
Yes.
I was
Told that.
called back into it and told that he said.
So whose statement was
That's what he asserted in his
Someone
evidence.
else's, yes.
He was authenticating some other
Yeah.
witnesses.
Yes, I think it's.
And then he's called back to Mr. Pitman.
I think it's the man to whom it was said that some of the goods had been sold,
Yes.
Mr. Morris.
And then he's called back.
Now fit and ready to give a statement.
Wanted to, yeah.
Yeah.
He's now fit and ready to give a statement. I repeated the questions and so on. So he said this all out. Now, in my respectful submission, of course, this doesn't really arrive. In one sense, my lords, we're treating this as if there hasn't been an appeal before on this point. But I do, if one's asking, bearing in mind what we now know about his mental condition, I do submit that one can still be certain that this was a voluntary statement. That's what the judge found, and there's no basis for saying, bearing in mind this material, no basis for saying that, well, actually, the court should have concerns as to either the voluntariness or the fairness of admitting the statement. The Justice of the Peace, with a contemporary record, has set out what happened and his involvement in the taking of the statement.
Yes?
That's what I say on the admissibility of the confession. I say that the court can be, that there is no basis on there's no reason on the basis of the fresh evidence to say that the court should come to any different conclusion on voluntariness or fairness than the judge himself did. Or that there are sufficient reasons for concern in what you might call the contemporary material, which gives rise to a suspicion, a genuine suspicion of unfairness. Therefore, I submit the confession was rightly admitted, and nothing in the fresh evidence alters that. Can I now turn to the Joji point? And there are two issues that arise on this. First of all, is special leave needed to argue the point for the appellant? The appellant says, well, look, I don't need special leave. The issue is live, as it were. I'm here on an appeal anyway. My appeal isn't completely over. The second issue is, if special leave is needed, should it be granted? Can I deal first with the first issue, is special leave needed? In my submission, the answer is yes. On the basis of the facts before the Privy Council last time, the board made a final decision. And you see that at paragraph 25 of their judgment. Perhaps I can just ask you to look at that. That's in, I think, the first record at page 49. And it begins, this is a judgment delivered by Lord Carswell, it begins about 8 lines from the end, their lordships. Their lordships consider that the judge's directions to the jury, although they could have been less diffuse and more focused on the issues, can be said to have covered the necessary ground by making it clear at several points that it is essential that the defendant is proved to have foreseen and so contemplated that a murder might occur and still remained part of the joint enterprise. It was leaving the jury to apply that principle to the facts, whereas it would have been more appropriate if the judge had spelled out the various ways in which it might be said that the appellant was not part of the joint enterprise, the murder of the victims relating the material parts of the evidence to each. The board does not consider, however, that the lack of such specific directions made the appellant's conviction unsafe. So the board has dealt with the position already and come to a final decision. Now, my lady, if, as I said it was, the Court of Appeal was correct to say the new evidence makes no difference to the admissibility of the confession, the board's decision remains final, and there's no basis, the board's previous decision on this issue remains a final decision, and there's no basis for interfering with it, as there are no new facts which have come out which would trigger the requirement to consider this issue in the light of the changed law. Suppose, for instance, that the fresh evidence really did make a difference. Supposing it had said, well, you know, he's the sort of person who simply couldn't form any sort of foresight or anything like that, and he certainly couldn't form any conditional intention or intention. Supposing that was the effect of the new evidence, one might say, well, I'm going to have to reconsider this whole question of joint enterprise in the light of the fresh evidence, because it really makes a difference. But in my respectful submission, the fresh evidence doesn't make any difference to the question of joint enterprise. It doesn't take the matter any further. And therefore, the appellant cannot use, if I may put it slightly pejoratively, he cannot use the existence of an unsuccessful appeal on fresh evidence on the confession point as a reason for getting the board to reconsider its previous ruling as of right. And therefore, he does need leave. And therefore, the board has to approach the question of joint enterprise directions on what you might call the substantial injustice test, which is referred to in, I think, paragraph 100 of Joji. Now, my lady, it won't surprise you to hear, when we read Joji, my learned Jude and I did a lot of research to find out what does substantial injustice mean. And we didn't act. The best we could do was, there's a decision, I think, of the Court of Appeal, of Lord Chief Justice Bingham, as he was, in a case called Hawkins, in which he says one should eschew undue technicality in deciding that issue. And the reference for that is volume 4 of the Bundle of Authorities, tab 78, page 1814, is where it starts. The relevant passage is at page 1820. I don't think I need to take you to it. It's just the phrase, eschew undue technicality. Now, I do, however, submit the following. In applying this test, it cannot be right, in applying the substantial injustice test, it cannot be right that the court applies what the usual would the jury inevitably have convicted test with the right direction on the changed law. If that were the case, every single appellant would be entitled to complain, and you'd completely undermine the substantial injustice test, which is obviously designed as a bulwark, if I can put it this way, against a flood of out-of-time appeals. And the reason for that is you need certainty in the law. Likewise, I submit, you can't just say...
It's more that you need finality of decision-making.
Yes, you need finality of decision-making. And in my submission, likewise, you can't just say, look, because of the misdirection, I'm now facing a sentence which isn't quite the same as the sentence I might have received, let's say, for some lesser offence. Again, otherwise you'd have the same problem. Everyone would be coming along saying, on the correct direction, I would have been convicted of offence X rather than offence Y, and I therefore would have had a slightly different sentence. I'm just taking this as a general point for the moment. And the whole premise of the rule is the need for finality in the law, even though convictions and sentences have in fact been based on a mistaken application of the laws previously understood. Now, if I can give an extreme where I would accept, obviously, that a court of appeal would have to grant leave. Suppose, on the correct direction as now understood, a defendant could not possibly be convicted of anything at all. Well, then there's obviously been a substantial injustice. He can say, look, there's no way I could ever have been convicted had a correct direction been given. And there is a case about possession of drugs with intent to supply. The Court of Appeal said, in effect, look, if the law had been properly understood, this man simply couldn't have pleaded guilty to the offence because he wasn't necessarily guilty at all. One can understand that. And likewise, my lady, my lord, supposing on a correct direction, the sentence which the defendant is serving or facing would be of a wholly different type from the one which he is serving. And supposing in this case, for example, I make a point against myself, supposing in this case it was the case indeed that the appellant was facing the sentence of death. And now we'd have to say, well, on a correct direction, he wouldn't inevitably have been convicted of murder, he would have been convicted of manslaughter. In those circumstances, one can see the misdirection has fundamentally affected the nature of the sentence that's been imposed on him. But in my submission, that's just not what we've got here. I submit, for the reasons we've set out in our case, first, that even on a correct direction, the conviction, there probably would have been a conviction for murder anyway. I'll explain why in a moment. Secondly, I say that the sentence which has eventually been imposed upon the appellant by virtue of the commutation is either the same as what would have been imposed on him by the Court of Appeal on the basis of a conviction for manslaughter or felony murder, or at least is not so materially different as to amount to a substantial injustice. If I can deal with the first point first, namely, the appellant would probably be convicted for murder anyway. I don't go so far as say inevitably. I can't go that high. But I do make these points, and perhaps one can take it to make good my submission. Could I ask you to go to the first part of the record, at page 475? I think actually it may be, sorry, it's the second, it's the second, supplementary record.
Supplemental.
And this is where one sees typed out the relevant parts of the confession. 475, line, pick it up, line 14. When the rain started to fall, lying in dread, I told him, let us go home, and he told me he having to go and get those things today. We were sheltering under a tree, so he knows they're going off for a robbery. It was dark, now starting to get dark. The people in them who was there had left, and he told me to come and walk in the yard and go inside. He held the man, and I held the woman. The man tried to run, and he pulled out a blade, carried them, that must now be the man and the woman, in the bathroom, he tied them up and stuffed the mouth. Now, as my Lord Toulson pointed out yesterday, the obvious inference from this is that the appellant himself has handed over to Agard, the woman, in the knowledge that Agard's got a knife. And then it continues, I asked him what he was doing, and he told me, let's pack up the car with the items. It had another lady, an old lady, where she was in a small room, and he went for her, tied her up too. He put she around by the rest in the bathroom. Then I told him, let us go, and he told me, he coming now, we went with a knife in the hand of the bathroom. Before that, the two of us were packing the items in the car, so they were carrying out the robbery. The two TVs, a radio, something in a black bag, I ain't sure what it was, black plastic bag. And then he continues at the foot of the page, I did find he was staying long, and I went back inside the bathroom, I tell him, let's go. I look inside the bathroom to see the three people lying down on the ground. I see blood, and so on. I killed them. He said, I killed them. We walk through the house, get the car, and leave. I ain't sure what he'd do with the knife. We drive the car downtown, come up the road, went to Chamfleur, he'd drop off the radio by a low hair fella. He did go in the yard, and I remained in the road. And I went in the home with 500 in my pocket. which I took from the house, on top of the dressing table next day. And then just two other points to note. First is he realises that he's going with Agard, going back to page 474, at the foot of the page, page line 45, he realises that the two of them are going to Agard's house to commit the burglary. Daniel Way tell me right, he's going by relatives to pick up a radio and other items. And that's the first point. And the second point is page 476, line 17, or 15 it begins. When you say you went by a house, where was the house? Answer, that house is in Cascade. It's a good side house, and that was his family house. Now, in my submission, one can make the following conclusions. First, as the jury found, he must have foreseen the possible use of the knife to commit serious injury at a bare minimum. But in my respectful submission, the natural inference in this statement is, having foreseen the possible use of the knife and continued participation in the robbery, he must have intended that, if necessary, the knife should be used. How, otherwise, were they going to get away with having committed this robbery against people who knew Agard? The only way, in one sense, that is the natural inference. The knife is going to be used not just to threaten them. It's going to be used, and he intends, if necessary, it will be used, to do them serious damage, if not to kill them. That's the natural inference. And the difficulty is there's nothing in this statement which suggests that he didn't really have any sort of conditional intention. Well, I had absolutely no idea that he was going to do this. I mean, obviously, the implication is quite the reverse. He foresaw it. My lady, my lords, the difference between foresight and conditional intention is not that great, in my respectful submission. In real terms, if it's obvious I foresaw something and continue to participate in it, I foresee an attack, then most people, unless there's specific evidence to the contrary, will draw the inference that, well, I intended that if necessary, the knife should be used. Why was I continuing the attack otherwise?
It's probably totally irrelevant, but do we know why Agard's appeal was successful?
Oh, I did know. What was it? It was found that...
I think because it defended on the terms of his confession,
Yes.
which, when read alone, were not regarded as sufficiently inculpatory.
Yes.
That was a misdirection.
Yes. I think there may have been a misdirection
On
his statement. Yes.
Thank you.
So he got...
I mean, he certainly didn't say in his statement that he was the principal. I think they both said it was the other one who did
I
it.
think the board, in its previous judgment,
It's probably in the previous
I
judgment.
think it's in the previous judgment of the board.
Agard's confession attributed most of the violence to somebody whom he called Cudjoe.
Yes.
Whether that was meant to be this man or not, it wasn't clear. But in any event, it wouldn't have been any evidence against this man, so it's irrelevant.
Yeah.
Thank you, Ben. But anyway, my name...
And neither of them gave evidence, is that right?
Agard did.
Agard did.
Yeah.
So that's my first submission. This is a case where there is a good probability that the jury will be convicted in any event, even on a correct direction.
But I think, having said that, I think Agard gave evidence that he wasn't there at all.
Yes, probably. I
He didn't give evidence.
I think he ran an alibi at the trial.
Yes.
He didn't give evidence that Mr. Pitman what done it.
No.
No.
Cudjoe was the third party.
Cudjoe. It was Cudjoe, yes.
Cudjoe was the third party.
Paragraph 13 of the board's previous judgment. He blamed Cudjoe for the acts of violence. My lady, that's my first submission. This is a case where the jury probably would have convicted in any event. The second is this. The Court of Appeal imposed the sentence it did, not because of the label murder, but because of the savagery of the triple killing, which, on the jury's finding, the appellant foresaw. And it's those facts that invoked the court's reaction to pass the sentence that it did. It's the facts rather than label. And one can see that from the Court of Appeal's judgment in the, I think it's the first part of the record, at page 358, line 73. Begins at page 72, paragraph 72, says there are no special circumstances justifying departing from the general guideline in Pratt and Morgan, hence the commutation with the not to be released period. 73, in doing so, we have taken into account the savagery of the murder. This was a triple murder involving a home invasion.
So the paragraph 72, the reference to 40 years, isn't a reference, or isn't included in the reference to the general guidelines, is it?
No. He's not to be released before the expiration of 40 years.
I follow that, but I had rather read that as applying whatever the general guideline was.
Oh, no. I think the general guidelines are reference back to Pratt and Morgan, as I understand.
It's the 5-year principle, isn't it?
Yes.
Okay.
Yes. In doing so, we've taken into account the savagery of the murder, a triple murder involving home invasion, which victims are hog-tied and butchered, and the appellant and accomplice spent the next few days casually disposing of the goods stolen from the residence. No expression of remorse. Still a relatively young man, we've taken into account the comments of Dr. Maharaj, likelihood of reform not explored in any detail, but leaving open the possibility of release before the end of his life, but only after serving a minimum term of 40 years in prison. Now, in my submission, it is important that on a conviction of manslaughter, the court would have had jurisdiction to impose exactly this sentence. I'll come to the minimum term point in a moment. And in my submission, it would be what the Court of Appeal was doing was looking at the facts, and the Court of Appeal is entitled just to look at the facts. On the law as understood, this might have been regarded as a party who involved himself in as a secondary party in a murder, guilty by virtue of foresight. In fact, he wasn't guilty of murder by virtue of his foresight and participation, but he was most certainly guilty by reference to all the same facts of manslaughter. And all the facts that the jury found could, in my submission, properly be taken into account in assessing sentence. It's wrong in principle, in my submission, for the court to say, well, the only verdict which the jury could have come to was manslaughter. Therefore, we ignore the finding made by the jury that the appellant participated in the attack with the relevant foresight. The court has to proceed on the premise that the Court of Appeal has taken into account the facts as found by the jury. And if that's right, I submit it doesn't matter whether the label one applies to this is murder or manslaughter. And so the Court of Appeal, in any event, was entitled, and I submit would probably, in any event, have imposed.
They certainly don't make that clear.
Sorry?
They certainly don't make that clear.
No. Well, they don't. Well, of course, they don't have to consider at this point the question of murder or manslaughter. It's not
No, they didn't.
for their mind. But to which my...
So it's really speculation as to what they might have done.
Well, the logic...
And we might think...
You might think. The logic, in my respectful submission, of what they're saying is the savagery of this killing as found by the jury. And I submit that really the label shouldn't make a difference in principle to the sentence imposed. It's the facts as found that matter, as long as the sentence you eventually impose is one that could be imposed to the alternative offence. And in my submission it can. I think it's common ground that the manslaughter obviously can attract a sentence of life imprisonment. But we have also got the Interpretation Act, which shows that when imposing a sentence of life imprisonment, you can also impose a minimum term.
Is that any sentence of life imprisonment?
Well, perhaps I should take you to the statute more helpful. I've only just seen it myself.
It looks like it might be, but...
I'm not sure if we have it in loose or whether it's in a bundle, but we have the Interpretation Act, as I've got it with a note to be handed up.
We've had that this morning, I think.
I think so, yes.
Ah, thank you.
Thank you very much.
No, no.
Thank you very much.
Thanks.
Thank you very much.
It's... Shall I see this now?
Which
It's 69A,
Yeah.
where punishment of imprisonment for life is provided for a criminal offence by any written law. That clearly does apply here. The court, on sentencing any person convicted of that criminal offence to imprisonment for life, may, notwithstanding anything contained in any other law, declare at the same time a period before the expiration of which, in its view, the person shall not be released. In my submission, that's a complete answer to the question whether the Court of Appeal had jurisdiction, or would have had jurisdiction, to do what they did on a conviction for manslaughter.
Is life imprisonment for manslaughter imposed by a written law in Trinidad
Yes,
and Tobago? It's not a common law offence?
The sentence is imposed by written law, and I think...
I'm not being sceptical about it, I'd just like to know the answer.
I think the answer is yes, it is, and I think it's in the...
Try section 6 of the Offences Against the Person Act. May not.
It should be in the main bundle of authority, the first one.
Wait a minute.
Tab 4.
Yeah.
Section 6, at page 72,
Yeah.
bundle 1. Any person who is convicted of manslaughter is liable to imprisonment for life, or for any term of years, or to pay such fine as the court shall reward. Page 72 of the first tab. So, first bundle.
Yes.
So, in my submission, the court would have had jurisdiction to do exactly what they did. There is also the alternative point, the importance of which I think perhaps slightly is less important.
But they weren't actually doing that.
They weren't, no. But what I'm saying is the Court of Appeal
had power to do it.
Could, and I also say would.
Well, that's
and therefore, the point obviously is, where's the substantial injustice? If in fact you've landed up with a sentence,
well,
which is
one answer to that will be we'll ask the Court of Appeal.
Well, you could, I suppose, my lord, but my...
Well, they're the ones who are exercising this power,
Yes,
not us.
yes. Well, my submission is that the logic of what they said leads to the conclusion they would have done it anyway. And that's why I say there's no substantial injustice. If I'm wrong about that, well, so be it. There is also the other point about the felony murder. In my submission, the court, on any footing, the appellant was guilty of, under the felony murder rule. He was therefore guilty of murder. And under the felony murder rule, there was a discretion to pass the mandatory. There was a discretion to pass the death sentence, and therefore there would have been a jurisdiction to pass exactly this commuted sentence on that alternative basis. Now, I should just say one point, that the discretionary, in relation to felony murder, the discretionary, as it's only a discretionary life sentence, which is provided for by the felony murder rule, it would normally only be imposed in the worst of the worst cases. So I think the argument against me, which Mr. Fitzgerald takes, is, look, how could the Court of Appeal have, on the basis of felony murder, said, well, we would have imposed the death penalty, because they could never have got to that stage in the first place. In other words, although there was a jurisdiction, it was one they couldn't properly have exercised. But in my submission, the point rather falls away if they could properly simply have done exactly what they did under the manslaughter provisions, and that's what I principally pinned my case on.
So, if they'd been found guilty of, suppose the jury, in some, as far as I can see, more or less unforeseeable circumstances, would be considering felony murder.
Yeah.
Supposing it was.
Yes. Yeah.
And suppose it found the guilty of felony murder, unless it was one of the worst of the worst cases, the court couldn't impose a sentence for life.
Of death.
Sorry, of death.
No, it couldn't. I accept that.
And Trinidad says you have to go through two stages in order
Yes.
to...
Yeah.
And they patently were not gone through in this case.
My lord, that's why I don't particularly advance the felony murder route, as were for justifying the Court of
You
Appeal.
get to the same question on sentence, don't you?
Yes.
Are you able to say they would have passed
Yes.
the same sentence as they eventually did, or must they be given the opportunity to say whether they want to?
Yes. My submission is they certainly could have passed exactly the same on the manslaughter basis. Secondly, my submission is
That wouldn't arise if they'd found them guilty of felony murder.
Sorry?
They never get to manslaughter.
Well,
If he'd been convicted of felony murder,
yes.
you'd never get to the manslaughter.
No.
No, but you'd get to the life sentence or
But you might get to the life sentence.
Certainly get to the life sentence point under the felony murder rule. But there is, the trouble is there's no statutory provision that says in relation to felony murder.
But suppose we think these are matters which should be decided by the Court of Appeal, the sentence questions.
Yes.
What is your submission that we should do about felony murder?
Well, all these submissions only go, as it were, to the point that the sentence which the Court of Appeal eventually, the commuted sentence which the Court of Appeal eventually imposed was one which they would have imposed in any event. Therefore, there is no injustice. If your lordships were to find that this is not a sentence at all which the Court of Appeal could ever have imposed, or should or could have imposed, then my learned friend is in business, because he might say, well, look, there is a substantial injustice because I'm going to be subject to a sentence which is far greater than that which it should have been had the Court of Appeal appreciated the point in Joji. But I do it. But my point is, well, the Court of Appeal could and would have imposed just the same sentence.
I just wonder about that. Mr. Fitzgerald, in his note on felony murder rule, paragraph 3, draws attention to the decision of the Court of Appeal of Trinidad and Tobago and Nicholas and others,
Yes.
that a life sentence in a discretionary death sentence case should be reserved for cases where the appellant is beyond rehabilitation or reform. Now, you're looking at somebody who's aged 22 with a low intelligence. Is it inevitable that they would have taken the view that he was beyond rehabilitation or reform?
I think they actually said in their judgment he's not necessary. I can't remember.
Yes, I think they rather suggested the opposite. That
Yes,
he was, however.
Well, it should not be considered as a starting point. Don't forget this is a triple kill.
Well, we may need to look at what they said in Nicholas.
Well, we have Nicholas. Wait. It's on the air.
Nicholas, paragraph 59.
Yes.
Thank you very much. Since none of the reports indicates that any of the appellants is beyond rehabilitation or reform, a life sentence would appear to be inappropriate in the circumstances. Now, you may say the circumstances of that case were much milder than this. I don't know.
Well, I've not had a chance to read this case. But in the circumstances, it's the important point. And the Court of Appeal had well in mind the circumstances of this case.
But they don't seem to have considered rehabilitation or reformation.
Well, they do. In this case, the Court of Appeal did. I mean, they said they don't exclude the possibility of that. That's why they're prepared to make it life mean not... That's why life doesn't mean life, but will impose a term of 40 years, just going from my recollection of the judgment. Yes, that's right. So in other words, they are taking into account the point about rehabilitation. They say that's why we're imposing a minimum of 40 years.
Well, actually, life does mean life.
Yes.
Well, yes.
No,
Well,
With a minimum of 40 years, with the possibility of parole thereafter,
Yes.
as I understand it.
but that's what that was the Court of Appeal's reason. They were taking that into account.
well, you haven't had a chance to look at Nicholas, but if you look at paragraph 59 of Nicholas, it rather looks as if when directly confronting the question of whether a life sentence should or should not be imposed, with or without a minimum term, this court concluded that it should be done, or would appear to be inappropriate, unless there is an indication that the appellants are beyond rehabilitation or reformation. Now, whether they would also impose it on the basis of the particularly unpleasant facts of the offence, I'm afraid I haven't read enough of Nicholas to know, but it may be that, I mean, one possible view is that they clearly could have done it, and as you urge us to say, would have done it.
Yes.
Another possibility is that they couldn't have done it. I can't at the moment see any basis for that, but the intermediate possibility is that on a question of sentencing practice, it's really they who know what the local practice is, rather than this board.
Yes.
Yeah.
But paragraph 36 deals with the appropriateness.
My learned friend refers to paragraph 36.
And 37.
Yeah, so it's both conduct and rehabilitation. Yeah. 36, 37.
Well, paragraph
The real
36.
trouble in our case is that there's no report really addressing this question at all.
No.
And most courts of appeal would probably think it was desirable that they should be. What conclusion they would reach then would be obviously a matter for it.
I've made my submission.
Quite.
You have to have my point. I don't think I say the real question is, was there substantial injustice? If your lordships find there was, then leave should be granted, and then people have an opportunity effectively to get a different sentence. If I'm right in saying the sentence was one which would have been imposed in any event, then there's no substantial injustice. That's what it comes to.
I think we've got that point.
Can I go to, I'm not going to repeat it again. Can I go to appeal against sentence? My lady, I submit the question in this case is not what should the law be, or what is the right decision, but whose decision is it? And I put the question this starkly. Is it for the courts to develop, and I submit it plainly is develop in the sense of change, the law the way Mr. Fitzgerald suggests, or is it for Parliament? And we say manifestly, any change to the law in relation to intellectually disabled defendants in murder trials is for Parliament, not for the courts. First, this is a highly controversial and difficult area. The law of murder is difficult and controversial enough as it is, but when you add on top of that the death penalty, it's probably the most controversial and difficult area in the law. And it is one in which Parliament has already spoken, when, in 1985, it adopted the law of diminished responsibility in the same terms, materially, as the 1957 Homicide Act in England and Wales, and thereby provided that those whose mental responsibility for the killing was substantially diminished should not be convicted of murder. And that's what happened in 1985. Parliament stepped in and said, in relation to intellectually disabled people, you will not be convicted of murder, nor will you face the sentence of death, notwithstanding the fact you would otherwise have been guilty of murder, as long as your condition substantially diminished your responsibility. Per contra, however, or rather by that, Parliament substantially mitigated the harshness of the law relative to the intellectually disabled, amongst others. But, in my submission, this is important, it deliberately chose to leave subject to the law of murder and to the mandatory sentence it requires three main categories of intellectually disabled people. First, those whose responsibility for the murder was not substantially diminished by their condition. One pauses parenthetically there to say, well, not altogether straightforward. It's not easy to see what's wrong with that. If you do suffer from, let's say, you're intellectually disabled, but what you've done is the most vicious thing possible, Why should you be put in a different category from all other murderers? The second category, which was still exposed to the law of murder and therefore the death penalty, was those who could have run the defence of diminished responsibility, but who chose not to do so. Now, whether Parliament realised that was going to happen doesn't matter. That was the consequence of what they did.
Yes, you said the Parliament deliberately left these three categories. I don't think you really meant that.
Well, it didn't provide for.
What it did was X. Whether it foresaw every consequence of X,
Well,
we're not in a position to know without looking at impermissible evidence. So.
no. But it definitely intended to leave in the first category, and that's clear from the terms of the Act itself. Secondly, it does leave in those who could have, it does leave exposed to the sentence those who could have run the defence but decided not to do so. And again, one might say, well, that's not a wholly irrational way of approaching things because the law does need certainty. And if it were otherwise, you're going to have a situation in which I could run the defence of alibi, get convicted, then pop up in the sentencing court and say, well, by the way, I am actually a person suffering from diminished responsibility, and then persuade the judge, I suppose, that actually I should not be sentenced to death. I should, in fact, be treated just as if I'd been found guilty of manslaughter by reason of diminished responsibility.
A person who's convicted of felony murder,
Yes.
and who has not run diminished responsibility, either because it presented an obvious problem in relation to their primary defence,
Yes.
or because, although there was quite a good case of saying there was a degree of diminution, doubtful whether it would pass the substantial test,
Yes.
could nevertheless raise that as a mitigating factor at the sentence stage, couldn't they?
Yes.
Yeah.
Now you could, yes.
But by contrast, somebody who's got the death penalty
Yes.
can't.
No, he can't because it's mandatory.
And there's might be thought, something rather unsatisfactory about that.
Well, that, if I may anticipate, that may be what the court thinks. Whose job is it to sort that out? My respectful submission, it's not for the court to sort that out. At the moment, the way it would be dealt with under traditional principles would be that this would be, as well, let's say, the intellectual disability or the other disadvantage of the mind would be something which no doubt one could pray and aid in seeking mercy from the advisory committee. It would be a relevant factor to put before them.
Well, then, same point, I think, arises in relation to your first category, because there are the word substantial has given rise to, as you know, a lot of difficulty. Law Commission looked at it when it did its investigation of partial defences, and the problem's got no easier since then. There have been a series of decisions on the case, most recently one, the Court of Criminal Appeal, case of Golds. Now, may we take it as a given that in Trinidad and Tobago, substantially impaired means something more than, not minimal?
Something more than minimal.
Yeah, but it means something significant.
As I understand, it's more than minimal.
Anything which is not trivial.
Yes. Well, more, I think the phrase is more than minimal.
Well,
that would be understood because, I mean, of course, their law for its responsibilities mirrors exactly what our law used to be. And of course, the decisions of the board, I'm pretty sure, Mr. Poole drawn my attention, will adopt exactly the same approach to diminished responsibility as was adopted in the English courts.
Well, we may need to look at that, but if it be the case that you can have somebody whose responsibility is diminished to a degree, but not substantially,
yes.
Question arises, is it cruel and unusual punishment to inflict the death sentence on that person, therefore making no account of the degree of impairment in a way that could be allowed for in a non-mandatory case.
Well, in my respectful submission, that would be a very fair question for Parliament, but it's not a question
Why
for Lordship.
isn't it a fair question? Because if we recognise that there has for long periods of time been a common law principle against inflicting death on the mentally abnormal, and understandings of mental abnormality have leapt forward by leaps and bounds, why don't the judges have a responsibility to say that cruel and unusual punishment may include the imposition of death on somebody who has a mental abnormality which has made a contribution?
Well, my Lord, if the premise of your question is right, I can see you would have a jurisdiction to do it. My submission, and I will develop it, is the premise of the question is right. There is, in my submission, there's no general free-floating common law principle in relation to the death penalty that says the courts can intervene to stop, in relation to the mandatory death penalty, which is expressed in mandatory terms, the court has a general power, so to speak, to intervene, to stop the infliction of it in circumstances where it's being imposed not on an idiot or an insane person, but on someone who is suffering from a mental disability. I will be developing that submission in due course.
Yeah.
Clearly, my Lord, if the position is, if the correct analysis of the law is that there always has been a free-floating, and there still is, a free-floating common law jurisdiction, common law power, or duty on the court to prevent cruel and unusual punishment, and it's unrestrained by precedent and how it's been applied in the past, then, of course, Mr. Fitzgerald's in business.
Now, when the law...
But my submission is there's never been this... I mean, Mr. Fitzgerald called it his Trojan horse, which I say exactly.
Right. Well,
don't let it in.
One other question.
Well,
Please continue.
yes. No, it is because... I'm going to have to develop these submissions in due course. I submit there has not been a general common law duty on the courts, or indeed power on the courts, to prevent the imposition, the pronouncement of the sentence.
What about the carrying out?
Well, that may be a rather different point. But the trouble is, on the facts of this case, that's a crucial distinction between pronouncement and carrying out.
The death sentence throws its shadow across the whole of this. When the Law Commission did its report on partial offences and murder, did a comparative study, unsurprisingly it found that across the common law world in general, there was a wide variation of methods used for dealing with mental offenders who are mentally disturbed to a greater extent or another. Yeah. But the countries it looked at were, apart from the USA, all non-death penalty countries.
Yes.
My question is there any modern common law state other than the USA which has retained the death penalty and where these issues have been considered in recent decades?
No.
No, right.
No, well, not that I know of.
So when you say there's...
What about India?
Oh, India. Yes, the child case.
Yes. Mr. Knox, I'm very well aware that you've got quite a lot of ground still to cover, particularly what we're now beginning to discuss.
Yes.
I'm not sure it's going to be very fruitful for us to debate with you whether it's our job or Parliament's job to confront the issues before us. I'd rather confront the issues, and we'll work out for ourselves whether this is
of course
a constitutional issue which lies with us,
yes,
obviously by definition as the Constitutional Court of Trinidad and Tobago, or whether it is something that we should indeed leave to Parliament.
But my lady, the reason, can I just explain why I say, and I'm not just making this as a general point, the reason I say this is something for Parliament to sort out, not the courts, is this. I say precisely because Parliament stepped into this area in 1985.
Yes, you've made that point.
Exactly.
You've made that point.
And therefore...
You told us that it left three categories of people And can we go back to the third of those categories, please? You haven't mentioned it yet.
Oh, those who did commit murder, while not suffering from any intellectual disability, but who later suffer maybe some accident or whatever, which substantially reduces their intelligence, so that by the time it comes round to sentence, or carrying out the sentence, they can be said to be intellectually disabled. And those, again, obviously the law of diminished responsibility does nothing for them. Now,
It's said to be the common law that helps them out.
sorry?
It's said to be the common law that...
Well, in my submission, I will be developing this. The common law has never gone so far as my learned friend says, and the common law wide principle for which he contends in my submission doesn't exist. That's going to be the point of my submissions.
Well, perhaps we could get on to them.
Well, can I just make more precisely, just the 3 points I want to make, so you know where I'm going. First, there was never a common law prohibition against pronouncing sentence on idiots or those who become insane. At most, at common law, there was a power to grant a temporary respite to such people, to give them time to put forward some lawful reason why a sentence should not be pronounced. And when I say lawful reason, something like benefit of the clergy, or there's been a misdirection, or something like that. A reason which would be a reason essentially for saying the conviction was wrong. The prohibition extended only to the carrying out of the sentence once imposed. And therefore, there's no relevant exception in relation to idiots and the insane, which can be extended to the mentally disabled in relation to the pronouncement of sentence. That's my first point. The second submission I make is that the manifest purpose and effect of the 1842 and 1925 Acts was to require the courts to pronounce the death sentence, pass the death sentence in any event.
(1825) and
1842 and 1925.
Yep.
Those are the two Trinidad Acts.
Yep.
Third, even if I'm wrong on the above 2 points, and even if there was a prohibition against passing sentence on idiots and the insane, and this survived the 2 statutes I've mentioned, first, none of the rationales which justified not executing the insane or idiots applies to those who are simply intellectually disabled. Therefore, it would be wrong to develop the law so as to include within that same protection those who are intellectually disabled. Secondly, and importantly, I respectfully submit that it is impossible to say that by 1985, when the law of diminished responsibility was introduced by Parliament, that the common law had already been developed, or would have been developed if anyone had thought about it, to the point that it was recognised that it would always, and in all cases, be cruel and unusual punishment to execute those who are intellectually disabled. Therefore, that being the case, it's not open to the courts now, so to speak, to outflank Parliament and to say that this should be done now by virtue of some common law power, by virtue of later developments since 1985. If I can put it this way, rather cliched way, I submit the clock stopped in 1985 once Parliament stepped in. If I can deal with the first issue first, was there a common law prohibition against passing sentence? If I may go back to the textbooks, the first is Chitty, and if I can take you to that, this is, I think, the one my learned friend principally relies on. You can see it as tab 8, volume 8, sorry, tab 128. Begins at 3276, and I think the relevant passage, forgive me, my lady.
3280. 3280.
3280
The other cause for which the judge is bound to grant a reprieve.
Yes, forgive me. The other cause is bound to grant a reprieve is the insanity of the prisoner. It's from the earliest period been a rule that though a man in the full possession of his senses commits a capital offence, if he become non-compos after it, he shall not be indicted. If after indictment he shall not be convicted, if after conviction he shall not receive judgment, if after judgment he shall not be ordered for execution. And this opinion is confirmed by the fact that the statute was passed in the reign of Henry VIII. My lady saw that, about allowing executions of insane people. The true reason of this lenity is not that a man who has become insane is not a fit object of example, though this might be urged in his favour, but that he is incapable of saying anything in bar of execution. And my lady, that's the point on which I principally rely. Or assigning any error in the judgment. The judge may, if he pleases, swear jury ex officio to see if he's really insane. But in my submission, the reason against passing sentence, the reason why you can't pass sentence is there's something which he might want to say.
I'm not sure that isn't putting it very narrowly, because that is, I had read that as relating to paragraph C, that to allow execution of people who had been the third category, person who was sane at the time but became insane.
Yes.
I may have misread it, but the reason, the reason is not the man who has become insane isn't a fit object of example.
Yes.
He's looking at the category of people who've become insane post commission of the offence. It's not saying that that's the sole reason for respiting judgment in the case of those who were insane at the time of committing it.
Oh, yes, but my lord, on this issue, I mean, we are now talking in this case about people who have been who are saying effectively. I mean, what Mr. Fitzgerald's argument is that there's always been a rule against executing those who have been found guilty of murder, but then become insane.
Yeah, he's only dealing with people who've become insane. If you read the first 4 lines of this passage, he divides up the stages at which they become insane, but all of them are after conviction.
Yes.
All of them.
Or after offence. Sorry, after offence.
After offence, yes. But in my submission, the important point here is the true reason is not that a man is not a fit object of example, though that might be, but he's incapable of saying anything bar of execution or assigning any error in the judgment. So this rule against pronouncing judgment is simply a procedural rule.
What's meant by judgment there? I took that to mean, in effect, the passing of sentence. Is that wrong?
No,
that's the only thing that happens after conviction.
Well,
is the passing of sentence. So I read, he shall not receive judgment, was a reference to passing of sentence.
Well, in my submission, no.
And then after judgment, after the passing of the sentence, the execution shall not be carried out if he becomes insane between the judgment, viz. The passing of sentence, and the execution.
But in my submission, no. Just going back, the true reason of this lenity is not that a man who's become insane is not a fit object of example. So in other words, the mere fact that he's insane is not a reason of itself, it's not a substantive reason for not pronouncing sentence, but that he's incapable of saying anything in bar of execution. That presupposes the sentence has been imposed, or assigning any error in the judgment. That's referring to the conviction.
He is here talking about reprieve, which he's identified at the first paragraph of the chapter as a mere delay in the execution.
Yes.
Because one of the things he's being protected against, being unable to say anything in bar of execution.
Yes.
That assumes there's been a penalty has been imposed, but he still might have some reason for saying, I shouldn't actually be executed. But if he's insane, he can't say that.
Exactly. The whole point of it is presupposing there's something he might have some lawful reason, which because he's gone insane, he simply can't mention. So the court, so the rule
that might happen either before or after.
Yes, correct.
Yes.
The sentence had been pronounced.
Yes.
Because people were always asked, weren't they, have you anything to say before sentence of death is passed upon you?
Sorry.
Yes, it was regarded as of critical importance
Absolutely.
that they were asked.
Yes.
So this is obviously referring to that possibility as well as to things that might happen afterwards.
Yes.
And in this
of
paragraph,
course,
he's contemplating people who are given a reprieve until they are or may become well enough to say whether they've got anything to say.
Yes.
And when they've said it, they can then be hanged.
Yes.
He goes on in the next paragraph to address more certain course of execution which altogether relieves a criminal from danger is the obtaining pardon, and that's more formally frequently granted after sentence than earlier.
But really, the simple point of one is this is just a procedural rule to give a man who's gone insane time.
A temporary stay.
Temporary stay, just give him time. It is not a substantive rule that sentence wouldn't be passed on an insane man, ever. It's a procedural rule. The rule, in other words, against for which Mr. Fitzgerald contends, applies to carrying out the sentence. I accept there was that common law rule, but I do not accept there was a common law rule against pronouncing sentence. And indeed, if one thinks about it, the logic is against Mr. Fitzgerald. That is because the sentence has always been regarded as mandatory. And to similar effect, if one turns to the next tab, 129, (3303), at the foot of the page, the final paragraph, before judgment is pronounced upon the defendant, the crier makes a proclamation commanding all manner of persons to keep silence while sentence of death is passed. But it's not necessary that this form should appear on the record. It's now indispensably necessary, even in clergical felonies, that the defendant should be asked by the clerk if he has anything to say why judgment of death should not be pronounced on him, and it is material, it is that this appear upon the record to have been done, and its omission after judgment in high treason will be a sufficient ground for reversal of the attainder. On this occasion, he may allege any ground in arrest of judgment, or may plead a pardon if he's obtained one, for it will still have the same consequences which it would have produced before conviction, the stopping of the attainder. If he has nothing to urge and bar, he frequently addresses the court in mitigation of his conduct, and desires their intercession with the king. After this, nothing more is done, but the proper judge pronounces the sentence. This may safely be done in general terms, though part of the indictment is defective, or the conduct charged in part is no legal offence, though the residue is sufficient, because the court will make the punishment proportioned to so much of the charge as is proved by the evidence. Now, again, the purpose, what is going on here, the purpose of this is man is given a chance to say why the sentence shouldn't be passed. And so obviously, if you have gone insane, you need time in order to enable yourself to put something forward. So the rule applied not to the pronouncing of sentence. The absolute substantive rule applied not to the pronouncing of sentence. It applied to the carrying out of sentence.
But the expression judgment in the first line of the last paragraph on page 3303 is a reference to the sentence.
Yes, it would be, yes. In other words...
that suggests is what was meant by judgment in the previous.
Yes, this
treatise.
Yes, this is, I should say, this is Hale, I think, writing in 1736. Sorry, I've just shown you Chitty.
Yes, it's the new edition, because the first 128 was the 1819 edition,
Yes.
and this is the 1826 edition.
Yes. But in my submission, one gets a similar point. Namely, this was, in relation to the pronouncing of sentence, this was a procedural rule rather than an absolute substantive rule. It gets the same point from the same volume 8, tab 129, I think.
I thought that was 129.
Sorry.
That was 129.
Tab 40, sorry. Well, tab 140. 3398. 142, is it? 142. 3398.
Sorry,
This is 142, page 3398.
Is there any difference between the passage in the 1826 edition of Chitty and the same passage or the equivalent passage in the 1819 edition of Chitty, which we find at page 3296?
Not on this issue, we understand.
Thank you.
Nor I think on the passage that Mr. Fitzgerald took us to originally, and you took us to just now. 3280 reappears behind tab 129 at 3305 to 6.
Yes, I do see. I apologise, my lord, yes. I think I've been working with
think
different
they're the
references,
same.
yes.
That's actually taken.
So although we've got two editions, they don't actually say anything different.
What you have got, however, as Lord Toulson pointed out, is the beginning of the chapter at 3277, which makes a distinction between a temporary reprieve and a final part.
Absolutely, yeah.
Same.
If I can go back to tab 142, I think I mentioned.
You did.
Page 3398. This is Hale writing in 1736 concerning reprieves before and after judgment. Reprieves or stays of judgment or execution are of three kinds. One, ex mandato regis, thus we find it done in 3HH.
So which page are you looking at?
That's 3398.
3398, thank you. Yep.
Three types of stays of judgment or execution. Ex mandato regis, thus we find it done in references given, or by some message, or by sending his ring, but at this stage it's ordinarily signified by the privy signet or by the master of requests. 2, ex arbitrio judicis, sometimes the judge reprieves before judgment as where he is not satisfied with the verdict, or the evidence is uncertain, or the indictment insufficient, or doubtful whether within clergy. And sometimes after judgment, if it be a small felony, though out of clergy, or, and this is the important point, or in order to a pardon or transportation. And these arbitrary reprieves may be granted or taken off by the justice of jail delivery, although their sessions be adjourned or finished, and by this reason of common usage.
You're missing the next page. The third
There's
version.
another page.
There's another page.
It's gone, is it?
Well, there's three different kinds, and there's only two referred to there.
The point I'm making there is the reprieve granted before judgment is where there's something wrong with the verdict, or maybe something wrong with the verdict the jury has come up with. The reprieve granted after judgment is, amongst other things, if a pardon is going to be granted. And that again, I suggest that the rule was always against carrying out the sentence once imposed, not against imposing it. And if I can go finally, I think, to Blackstone. Tab 135. think it's, it may be, I'm sorry, do forgive me, it may be a bad reference. I'm looking for page 759 of Blackstone, which may not be in this particular extract. My lady, can I come back to that? But there's a passage, if I can just give you the thrust of it, which is in relation to pregnant women. The fact that a woman is pregnant or quick with child operated as a reason not for not pronouncing sentence, but simply for not carrying out the sentence.
I mean, the bit we were referred to before was on page 3337. Possibly 3338, but 338, that is so illegible in my copy.
Yes, well, I have a feeling it may be in a completely illegible section, what I'm looking for. But in any event, if I may come to if I may find the reference after lunch, the point is that if a woman was pregnant with a child, that operated as a reason for not carrying out the sentence. It did not operate as a reason for not even pronouncing it in the first place. And what I submit, there's a common thread that runs through this. The jurisdiction to prevent, the jurisdiction was one to prevent the carrying out of sentence. Just as it was with pregnant women, so it was with those who become insane. There was no jurisdiction to not even to pronounce the sentence in the first place. All you could do is just defer, to give the man a chance, or the woman a chance, to say something which would operate as a good reason for not passing sentence, e.g. because the conviction was wrong. So I submit that what the textbooks do not support Mr. Fitzgerald's fundamental argument that there existed a common law jurisdiction to prevent the passing of sentence on the insane. My lady, we deal with the statutory position in England and Wales before the Offences Against the Person Act in 1861 in paragraph 17 to 21 of our case. The only important point that comes out of that is that from, I think, in the early 19th century, statutes imposed, or rather gave the court a power, quote, to record a sentence rather than to pronounce it. And that, however, was changed in 1861 by the Offences Against the Person Act, which is in volume 3 at tab 60. It begins at 997.
997.
997.
That's in tab.
Tab 60.
Try 977.
Sorry.
Well, my tab 60 goes from page 977 to 980.
977, sorry, 977, tab 60.
Yeah.
And you see, paragraph 1, whosoever shall be convicted of murder shall suffer death as a felon. And then 2, upon every conviction for murder, the court shall pronounce sentence of death, and the same may be carried into execution, and all other proceedings upon such sentence in respect thereof may be had and taken in the same manner as in all respects as sentence of death might have been pronounced and carried into execution, and all other proceedings thereupon in respect thereof might have been had and taken before the passing of this Act, upon a conviction for any other felony, for which the prisoner might have been sentenced to suffer death as a felon. And the reason there for the emphasis on pronounce was to make it plain that it had to be pronounced, not merely recorded. That's why you see the word pronounce there. And the acts, I don't propose to go to them, but the acts which referred to the power to record were the Judgment of Death Act 1823, which one can see at tab 50, and the Execution of Murders Act 1836, which you can see at tab 52, 949. After these statutes, the court in England and Wales, it seems, always pronounced sentence. One gets that, no matter what the condition of the man, pronounced sentence, and one can get that from the Royal Commission report, which is in volume 8, tab 145. And the relevant passage begins at 3501. Paragraph 217. Under the existing law, the question of the sanity of a person charged with murder may fall to be considered at 4 stages. As we shall see later, the criterion of sanity applied differs each. First, a person who has been committed for trial may be certified insane and removed before trial from prison to Broadmoor to a local mental hospital under section 21 to 3 of the Criminal Lunatics Act. Secondly, under section 2 of the Criminal Lunatics Act 1800, if when an accused person is brought up for trial, he appears in the jury to be insane and unfit to plead, they may find him insane on arraignment, and the court may order him to be detained during Her Majesty's pleasure. If he subsequently recovers his sanity, he is liable to be again brought up for trial, but in practice this will be done only in the most exceptional circumstances. If, for example, he's found to have been malingering of the insanities of a short duration. Thirdly, the Trial of Lunatics Act.
And what happens if it's of a longer duration?
Quite sure.
Stay in Broadmoor. Stay in Broadmoor. I think you'll find. Certainly in the early years.
Under the Trial of Lunatics Act 1883 provides that where it's given in evidence on the trial of such person that he was insane, so as not to be responsible according to the law for his actions at the time when the act was done or omission made, then if it appears to the jury that he did the act or made the omission charge but was insane, as aforesaid at the time, they shall return a special verdict to that effect, and the court shall order the prisoner be detained as a Broadmoor patient during Her Majesty's pleasure. The criterion applied by the jury to this is laid down in the Macnaghten rules. And then fourthly, under section 2.4 of the 1884 Criminal Lunatics Act, requires the Secretary of State, if it appears to him there's reason to believe that a prisoner under sentence of death is insane, to appoint 2 or more legally qualified medical practitioners to examine the prisoner and inquire as to his insanity. If they certify he's insane, the Secretary of State respites the capital sentence and orders his removal to an appropriate institution. But there's no suggestion here that by the time this report was being written, there was also some general common law power to prevent the passing of sentence, to stop passing of sentence. All this appears to proceed on the assumption that sentence is passed and then steps are taken afterwards to prevent the execution.
I mean, does the report grapple with the common law powers at all?
I'm not sure it does, no. I mean, of course, part of the problem is that there have been a lot of statutory intervention, as you can see. But the point I'm on at the moment is, well, there doesn't appear, it's the same point as before, there doesn't really appear to be a common law power not to pass sentence. It's not mentioned here. And likewise, I think at 3432, paragraph 22, no one would now dispute that for many of these crimes it would be monstrous to inflict the death penalty. The view is widely accepted that this penalty should be reserved for more heinous crimes of murder. In many other countries where capital punishment has been retained, the law has tried to do this either by confining the application of the death penalty to a more limited class of homicides, or by giving a discretion to the court to decide in individual cases whether the sentence of death should be imposed. In Great Britain, the law still reflects the concept of an early age that every murderer forfeits his life because he's taken another's life. This rigidity is the outstanding defect of our law. But the point I get from that is that it seems to be making the point again that there's nothing in English law which allows the court not to pronounce sentence. And likewise, page 3548. At this point, there's a discussion that begins at page 3544 on mental deficiency and criminal responsibility. But the point I want to draw attention on 3548 is that the various procedures could be, but haven't already been, transposed into English law. And you get that at 352. The proposal to extend this procedure to murder cases in England has the merit of simplicity. This is dealing with questions of mental deficiency, and is argued that it will also be logical, since there can be no logical reason for enabling a court to send a mental defective convicted of larceny or even attempted murder to an institution in lieu of passing sentence, but withholding such power from the court if he is convicted of murder. So again, the premise appears to be that the court has no choice when it comes to murder, as opposed to in other cases. And then finally, tab 127, which was, I think, an extract from Archbold in 1926. And page, tab 132 begins at page 3315. And you can see at 3316, there's a reference to respite. The term respite is usually applied to postponement of judgment or sentence of the court until a future date. This may be done where the court, having regard to the nature of the offence or the antecedents or mental or physical condition of the convict, desires to defer sentence. It is usual to put the offender under recognisances and so forth. On a conviction by a verdict for capital offence where judgment has been respited, it may be given by subsequent justices of delivery for the same jurisdiction.
Could you take them over the page and show them this section on reprieve as well?
Yes, again, yes. And then over the page, reprieve. A reprieve is the withdrawal of the sentence for an interval of time whereby the execution is suspended. And it may be granted either by the King or by the court empowered to award the execution. References are then given. A reprieve is grantable by the Crown, we've seen this before, at its mere discretion, grantable by the court at its discretion, whenever substantial justice requires it, or where the prisoner is a pregnant woman under capital sentence. As for reprieve in capital cases, references are then given. The judges of the size have power to reprieve after their commission is determined. To the end, a mastery to the end. Though the learned commission has observed that the continuance of this power is said to be of rather common usage than strict right. In two cases, the court is bound, ex necessitate legis, to grant a reprieve. First, where the prisoner under sentence being female is pregnant. Second, where the prisoner becomes insane after judgment pronounced. But in my submission, reprieve there is, i.e., sentence has been passed. And the person who has become insane is in the same position as the pregnant woman. You pass the sentence, but then you grant the reprieve because of their condition. Now, my lady, I submit this is an important point, because if it is right that the court always had to pronounce sentence, then the basis of Mr. Fitzgerald's appeal falls away. His whole case is the court shouldn't have pronounced sentence in the first place. Therefore, there was an error of law when the Court of Appeal imposed its commuted sentence, because it proceeded on the basis that the sentence had been properly pronounced and imposed, when in fact it shouldn't have been pronounced and imposed. Now, in my submission, on any footing, the sentence was correctly pronounced. Whatever one thinks about it, the sentence was correctly pronounced. It may very well have been that if the state had sought to carry it out, then, if the appellants were insane, then at that point the appellants would undoubtedly, subject to points I'm going to make later, would undoubtedly have had a right to apply to stop the carrying out of the sentence. But it can't be said that the appellants, even if they'd gone insane, would have had a right to stop the pronouncement of sentence. And a fortiori in the case of people who are mentally retarded. And I do submit that the rule, the common law rule, which prevented which as were required the court to hold its horses when a man went insane, so he could put something before the court, that cannot be transposed to the mentally disabled. If I'm mentally disabled, I will be able to say something as to why the judgment was wrong.
But if you're mentally disabled within the meaning of the rule,
Yes.
You could make those submissions to the court before it passed the sentence, couldn't
Yes, exactly. And that's why I say...
you? So why does it matter whether you make it before or after? I mean,
Well,
it has a certain legal attraction, I
Well,
suppose. In real life,
if you're mentally disabled, well, you wouldn't. The point would be that if you're mentally disabled, of course you could make your submissions before the passing sentence, but there would be no reason for the court to defer passing sentence in relation. The reason for the court deferring sentence.
well, it might not. It would depend upon the nature of the
Disabled, of course.
of your how
In
disabled
broad.
you were and what
But in broad,
might happen in the future, all sorts of things.
no, but in broad terms, the mentally disabled person will be able to say something, which is something relevant to a
He'd be able to say something relevant, and it would be relevant, would it, even if it wouldn't have been sufficient to
Yes.
amount to
Yes, exactly.
a defence of manslaughter on the ground of diminished responsibility.
But he wouldn't need, whereas the insane man does need a procedural rule which prevents a court from going straight ahead and passing sentence, because there might be, he simply doesn't, he can't say anything. That's not true of the person who's intellectually disabled. He does have his wits about him, so he will. You don't need to grant him an adjournment, whereas you do need to grant the insane man an adjournment. In other words,
But that's just a procedural question.
Yes, exactly.
If you look at the thing as a matter of substance,
Yes.
both of them can make submissions to the court,
yes,
which may lead to the sentence not being passed.
yes, exactly, yes, yes.
Or if it has been passed, to the carrying out of the. So if we're looking at the substance of the problem rather than its
Yes.
procedural.
Yes, yes, yes.
All this point is irrelevant, isn't it, really?
Well, the fundamental point is that there's no power in the court not to pronounce sentence. It always has to pronounce sentence. What happens afterwards, in the case of what happens afterwards, is the insane have the right to apply to the court to stop it being carried out. That was the law. And that being the law in relation to idiots and the insane, you can only extend that law to the mentally disabled. That's the point. May I turn to my second point, and that's the effect of the 1842 Act, which one sees in Trinidad, which one sees at tab 46. I think in volume 3. Page 915. And this is the ordinance passed in Trinidad in 1842, Section 2. 915. And be it enacted that from and after the promulgation of this ordinance, every person convicted of murder, or being an accessory before the fact of murder, shall suffer death as a felon, and every accessory after the fact of murder shall be liable to be imprisoned in the royal jail, or for any term not exceeding 4 years, and so on. But the important phrase there is shall suffer death. And in my respectful submission, that means, the effect of this section is that every person who is convicted of murder, without exception, must have the sentence of death pronounced upon them. Those words, in my submission, are unequivocal. Now, my learned friend says, oh, well, it must be subject to the common law exception. To which I say, why? The words don't allow that. Not in relation to the pronouncing of sentence. If I can take it in stages, this section obviously does not remove the Crown's power to grant a pardon. And one submission, I make these alternative submissions, one submission would be that the effect of this statute, being as absolute as it is requires the court, A, to pass sentence, B, takes away from the court's previous common law power to prevent the carrying out of sentence. And it simply leaves the position with the executive to grant a power of pardon. And that appears to be the structure of what is provided for, again in 1925. The 1925 Act, one sees, I think, in Bundle 1, tab 2, sorry, tab 3, begins at page 61. And page 62, clause 4, paragraph clause 4. Every person convicted of murder shall suffer death as a felon. And then at the same time you have the Criminal Procedure Act. Same year the Criminal Procedure Act is passed, which is at tab 2, which has in it section 70. Which provides for the power of pardon.
Yeah.
Procedure after pardon's granted.
Well,
Tab 2, did you say?
sorry, it provides for the procedure.
Page number, please.
Page 60. Tab 2, page 60.
Yeah.
And it's section 70. Now, putting these statutes together, what I see on the face of it one gets is that the previous common law power, even to prevent the carrying out of sentence, has been removed, and the matter has become entirely a matter for the President to sort out.
Now, I've still got open page 915, Mr. Knox, which is the first of these statutes that you took us to, the 1842 ordinance in Trinidad.
Yes.
And I've written down, I hope correctly, the submission that this takes away any power previously available either not to pass sentence or even not to carry it out.
Well, yes, in my submission, it certainly takes away the power not to, and on the face of it, seems to take away the power not even to carry it out.
And is that because it says shall suffer death?
Yes.
Well, now, do you say that that differs materially from the English 1861 Act? Is it which we've got at 977? Yes. Is it the presence of Section 2 or what?
Well,
because the 1861 Act says exactly the same.
Yes, it does in the first section, yes. The 1861 Act also has in Section 2 the business about pronouncing sentence.
Yes.
But the first section, I believe, from recollection, says shall suffer death.
It does,
yes.
In precisely the same terms as this does.
Exactly, yes.
So what's the difference?
Well, my lords, in my submission there isn't, but in my submission the question then would be, in England, what was the effect of the 1861 Act? And of course, on the face of it, you have my submission of the 1861 Act, plainly seems to proceed on the assumption the court has to pass the sentence. But on the face of it, it also seems to be providing that, subject, of course, to any later statute, that the common law power to prevent the execution of sentences being taken away too.
But the expression shall suffer death is completely absolute and would suggest that there's absolutely nothing that can be done, whether by the government or anybody else. Well, shall suffer death is quite clear. So the words can't be construed in their ordinary and natural meaning. They must mean something different. The only question is, what difference? And then the field is open.
Well,
the language, you can't really rely upon the language, because the language proves too much for you. Because you concede, do you not, if it's a matter of concession, that if a person is reprieved by the Governor-General or the Queen or anyone, then the person will not suffer death.
Yes.
And therefore, how can the statute have provided shall suffer death? There must be some sensible explanation for that. And it doesn't seem to be linguistic. So what is it?
Well, the explanation would be this. These statutes are providing what... I appreciate what I'm saying. I'm trying to interpret what was intended by the 19th century statute. But, my lord, I submit that it's most unlikely that the statute was intending to deprive the Crown of its power to grant a pardon. And that's why. But in other words, as a matter of
law... Why did Parliament use the word shall suffer death?
Yes, exactly. But I accept that it was not intending to take away the power of pardon, so that was that exception. And, my lord, it makes sense...
Doesn't that let the judge in just the same way?
No, in my respectful submission, not, because there is... shall suffer death is providing the legal result. The power of mercy is, classically, just a power of mercy. And that there is, and therefore, in my submission, it does make sense to say that was where the dividing line was intended to be. It is, in my submission, very difficult to say, right at the other end of the spectrum, that the dividing line was intended to be, well, actually, the court can still not pronounce death. There are two alternatives in relation to the shall suffer death phrase. One is only the power of pardon is preserved. The other is the court's power to prevent execution is preserved.
And to reprieve?
And to reprieve after sentence.
Does the 1861 Act, the Offences Against the Person Act, the Foundation English Act,
yes,
does that preserve the power of judicial reprieve?
I'm not sure if it does so in terms.
On your submission.
The judicial power of reprieve after sentence.
Yes.
Well, on the face of it, on the face of the words, no.
Unless it's done by Section 2, I suppose.
Yes.
Yeah, okay. All right. But it does seem to have survived, doesn't it?
Yes.
Or at least Archibald thought so.
Well, Archibald said, I agree, it does survive, yes. But, my lords, that was one submission. The alternative submission. The alternative submission.
So then we have to construe Section 2.
The alternative submission, just going back to the Trinidadian statutes, is the phrase shall suffer death should be read as keeping the law where it was before, namely the court must pronounce the sentence, but the court's power to prevent that sentence being carried out is still preserved. And my lady, the importance of the history before this statute is that it will give one an idea as to what the statute was intending to do by the words it used. And that's why I say, on any footing, and this is good enough for my argument, on any footing, this statute requires the court to pass the sentence, even if it does still leave in the court's power the power then to order the sentence shouldn't be carried out because of the subsequent insanity. But in my submission, that doesn't really affect the fundamental point. The court can't pass the sentence. The court must pass the sentence. My learned friend relies on the 1932 statute in tab 3, bundle 3, sorry. Which is at tab 47, I think.
Yes,
Page 919.
Page 919. In my submission, this is a point of anything against its construction. In my submission, the 1925 Act requires the sentence to be pronounced, and it requires the sentence to be pronounced even on a pregnant woman. Of course, there'd be the power subsequently to grant a subsequent reprieve. What the 1932 Act does is to prevent the sentence being pronounced at all. So section 3, section 2, where a woman convicted of an offence punishable with death is found in accordance with the provisions of this ordinance to be pregnant, the sentence to be passed on her shall be a sentence of imprisonment for life, with or without hard labour. So the change being effected by this statute is to prevent the sentence being passed. The implication being that previously the sentence could be passed, but it wouldn't be carried out. Now, the alteration is being made, the sentence won't be passed at all. And then section 3 provides for and the subsequent sections provide for the procedure to decide whether or not the woman is pregnant. So in my submission, again, this statute reinforces the fundamental distinction between pronouncement and sentence carrying out.
What was the position of a pregnant woman before this?
Looks as though subsection 5 of section 3 might help on that.
Maybe. Yeah.
Yes.
It's replaced.
I'm grateful by Lord Toulson. And that certainly was the previous position, common law, that the pregnant woman had a right to stop the sentence being carried out.
Was that under, even after the 1861 Act?
I can't, I'm not sure I'm able to answer that question, but it was the traditional common law position was. I think I've shown it was
There's nothing in the 1861 Act to protect the pregnant woman, is there?
No, don't think so.
Unless it's section 2.
Unless it's, yes.
Unless it's...
Yes. But I'm just on, for the moment, my lord, the narrow point about the difference between pronouncing and carrying out. And I say this is further support for the distinction. The rule in relation to pregnant women and in relation to those who go insane was against carrying out rather than against pronouncing. And then you have the 1932 Act, which says you don't even pronounce in relation to pregnant women. Can I just deal with some other statutes in Trinidad which have some bearing on this? The first is the 1877 ordinance in relation to mental health. Do we have this in the new bundle?
Yes. In volume 10, yes.
It's in the new volume 10. My lady and my lords, I don't know if you have a new volume 10.
Electronically.
Yes, we do.
It's the 1877 Lunatics Ordinance.
That's deferred delight.
Do you know it's not in
Do we have a volume 10?
Yes, we do. Well, at least we
No,
electronically.
It's not in there.
Do we have it? Or didn't we?
No, you put it. Sorry, it's only 46.
Yes. So we do.
Contain justice.
How exciting. Thank you.
I don't know, I've got the 1877.
My lady, is that the 1877 ordinance?
This is.
Good.
Is that what you wanted?
Yes.
I'm not sure it's in the policy 10, is it?
No, I'm told it's not in.
No, it's not.
I do apologise. I'm told it's not in. 10.
Well, it is right that no stone be left unturned in this case. So the fact that rather a lot of stones have been turned over bit by bit shouldn't worry us too much.
Which section is it?
Well, I just want to take you first of all to the beginning. An ordinance to provide for the custody of lunatics. I'm taking to this statute because it sets the context for the 1946 ordinance which you saw yesterday. And the preamble, whereas it's expedient that proper provision should be made in this colony for the care and custody of lunatics, and then a definition of lunatic is given in section 2, includes an idiot and any other person of unsound mind. And then section 4, just drawing your attention to this to show that at this point the statutory intervention in relation to lunatic appears to place a fairly limited meaning to the word lunatic. Section 4 provides for the power in the magistrate to confine a suspected lunatic. And then section 29 provides for the position of insanity before verdict. If any person upon arraignment before the Supreme Criminal Court during his trial for any offence is found by the jury to be insane, the court shall order that the trial of such person be postponed until he becomes of sound mind, and in the meantime be detained in custody from the lunatic asylum. And then section 30, whereupon the trial of any person upon indictment for any offence, evidence is given that such person was insane at the time of committing such offence, the jury shall be required to declare whether such person was acquitted by them on the ground of insanity. And then section 31, where the governor is satisfied that any person in prison for any cause is insane, he may by warrant direct that such person be removed to a criminal or colonial lunatic asylum. There doesn't appear to be any express provision in this statute to deal with the position of someone who becomes insane after a verdict.
And is insane itself given a meaning?
No, although the phrase insane was the subject, later the subject of the McNaughton rules, that word which you saw a moment ago in section 30 mirrors the English equivalent English provisions in relation to which the McNaughton rules were drawn up.
Earlier,
Yes, but they're not later, are they? They're earlier.
1842.
1842, yes, sorry. Of course.
They're extant when this is
exactly. Yeah, they're already extant.
passed.
So the word insane here is evidently being used in a fairly limited sense.
Well, it includes a person, an idiot or person of unsound mind, and that was the same
Yes.
definition that there was in
Yes.
English law until the Mental Deficiency Act.
Yes. But if I may go to the 1946 order.
So is a person who's insane a lunatic?
Yes, yes, because I think it actually defines it as such.
It
at
says
the
it
beginning.
includes an idiot and any other person of unsound mind.
Unsound mind.
Yeah.
Then you have the 1946 ordinance, which amends the ordinance you've just seen. And I think my learned friend Mr. Fitzgerald showed this to you yesterday.
It is now in volume 2.
Which is now in volume
Tab 166.
Okay, tab 166, page 4133.
Peter, it's in 4140.
4140.
Starts at 4136.
If I can go first of all to section 2,
Sorry, this is volume 10.
10 and 4133.
There's no hard copy.
I'm told there's no hard copy. Do we have it?
It's only available electronically.
It's in the, it's 4134 of the electronic bundle that has been submitted today.
Sorry, what was the number again?
4134.
Thank you.
It's section 2 you're referring.
It's section 2, which interposes a new section 4.
But that's all about civil commitment.
Indeed, but the reason I draw attention to is the unsound mind. What is the meaning of unsound mind here? And in my submission, it must mean, for this reason and another section I'm going to come to, it is, in my submission, not covering just those who suffer from intellectual disability. It's more serious than that. And you get that in particular from the section 3, which introduces a new 4B, which is on page 109 at the top, which I imagine is going to be 4137.
Now,
Whenever a judge, I think Mr. Fitzgerald showed this to you yesterday, whenever a judge or magistrate has reason to believe.
Mr. Knox, I've been making a note of this as we've all gone along, and it's perfectly understandable these documents are coming in afresh. Would it be possible at the end of this exercise for you to put on a piece of paper a chronological list of what you may take us through with the appropriate references?
Yes.
Thank you.
And just forgive me, what do you get out of 4B?
Well, the meaning of unsound mind.
Yes.
This is, in my submission, evidently not just mental disability. It's obviously something more serious than that.
Because it involves detention.
Yes.
Why?
Well,
Why such orders could be made in England under the Mental Deficiency Acts on grounds of moral insanity, feeble-mindedness, moral.
My lady, in my submission, mere intellectual disability would not be sufficient.
it doesn't make it compulsory. It only means that you can do it.
Well, if I can go to section 6, which introduces a new section 28. Where the governor is satisfied that any person in prison for any cause and any prison is of unsound mind, or where it's represented to the governor, any such person appears to be unsound mind, the governor may, by warrant under his hand, direct such person be removed to a criminal lunatic hospital or colonial mental hospital. And then subsection 2, in particular subsection 2B, provides where any person is detained in any hospital under this section, it shall be the duty of the principal medical officer, if and when satisfied that such person is of sound mind, to certify accordingly, and so forth. Whether in his opinion such person has been of unsound mind at any time subsequent to the passing of the sentence, and upon receipt of such certificate, the governor shall, by warrant under his hand, direct, if the term of imprisonment of such person is expired, that such person shall be discharged. B, if such person still remains liable to imprisonment or other sentence, that he be removed to the appropriate prison or place to undergo such sentence, or if not under sentence, to be dealt with according to law, as if no warrant for his removal to hospital had been issued. Provided that if such person is under sentence of death, which has not been commuted, such sentence shall not be carried out if the principal medical officer has certified that such person has been of unsound mind at any time subsequent to the passing of the sentence. And in such cases, the governor and council shall commute the sentence. Now, in my submission there, the phrase unsound mind, and it's obviously an important point, is being used not in the sense of mere intellectual disability.
And those new sections go into the 1932 ordinance, do they?
I think the 1877 ordinance.
Sorry, I beg your pardon, 1877.
Yes.
That's what I meant.
And so what Parliament appears to have done is to provide for a specific protection in relation to lunatics and those of unsound mind. But in my respectful submission, one gets 2 points out of it. First of all, this is only applying post-sentence. Secondly, in my submission, it is a bit of a stretch to say that this is applying merely to intellectual disability. it seems to be these provisions apply to something more serious than that.
Has anybody researched the Mental Deficiency Act and whether there were equivalents in Trinidad and Tobago?
But we haven't been able to find any equivalents. We did look yesterday for any equivalents in Trinidad. We haven't been able to find anything in Trinidad and Tobago.
Here's the 1878 Act, into which it's
The English Act.
No, this is the 18...
But is it your submission that intellectual deficiency is incapable of amounting to unsoundness of mind?
It might amount to unsoundness of mind, but merely on its own, no. I mean, taken together with other characteristics, yes. But here, my lords, we're talking merely about intellectual disability.
Peter, this is the Act into which it's inserted. You've got the 1870.
So, in summary, what I say is that the statutory provisions in Trinidad and Tobago do not allow this court to say that there was a common law power in the court to prevent the passing of sentence. All the statutory provisions appear to be proceeding on the basis that whatever common law power there was applied only after the passing of sentence. My lady, can I now come to my third point, which is how should the court develop the law? Can the court develop the law? And my first submission is there was no general common law prohibition that prevented the imposition of cruel and unusual punishments. Rather, there were specific exceptions which are established by long custom and usage with specific rationales which do not apply to those who are capable of understanding what they did and what they are about to face.
So there was no common law predecessor to the provision in the Bill of Rights, which prohibits cruel and unusual punishment.
Well, not in relation to the application of the death penalty, no. In other words, the way the jurisdiction arose in relation to the death penalty was that there were specific instances which would be recognised by the courts as entitling the condemned man to a stay of execution. But they were specific instances. And that is because the sentence of death was regarded as mandatory, and therefore you had to carry it out, save in special circumstances. And each of these circumstances had particular rationales. And in the case of preventing a sentence, in the case of insane people, the rationale, there were a number of rationales, but in my submission, the essential rationales is that he is in such a state that it would be cruel to execute him because he doesn't know what he's facing. His mind has gone. And if I can just go briefly to the judgment in Ford and Wainwright, which summarises the various reasons. That's in Bundle 1, tab 9. It begins at 201. And I think my learned friend Mr. Fitzgerald took you to the passages beginning at 208. In the second paragraph. But more particularly in 209, the last paragraph, where Mr. Justice Marshall sets out the various explanations that are given for not passing, or rather not executing, those who are idiots who are insane. It's 209 to 210, and then 210 over to 211 are the relevant parts of the judgment. Now, my lady, what I say in relation to these explanations is that whereas they would all undoubtedly apply to a man who is insane, who doesn't know what's going on, they would not necessarily, although they may sometimes, apply to a person who is intellectually disabled. So if one goes to page 209, one explanation, foot of 209, one explanation is that the execution of an insane person simply offends humanity. Now, my lady, pausing there, it's not necessarily the case that a person with intellectual disability who has committed the most violent possible crime with the full intention is not necessarily going to offend humanity. Another, that it provides no example to others, thus contributes nothing to whatever deterrence value is intended to be served by capital punishment. Again, it can't necessarily be said of all people of intellectual disability. It may be sometimes, but very often not. Other commentators postulate religious underpinnings. That is uncharitable to dispatch an offender into another world, and he's not in a capacity to fit himself for it. Again, that obviously applies to an insane man or an idiot, but not necessarily to an intellectually disabled man. Also said execution serves no purpose because madness is his own punishment. Well, obviously that doesn't necessarily apply to the intellectually disabled. More recent commentators opine that the community's quest for retribution, the need to offset criminal act by punishment of equivalent moral quality, is not served by execution of an insane person, which has a lesser value. Again, my lady, I do respectfully submit that it may sometimes be the case that would also be true of an intellectually disabled person, but not necessarily. And then Mr. Justice Marshall finishes, we know of virtually no authority condoning the execution of the insane at English common law. Now, in my submission, all that makes sense in the context of insanity, but you can't just say, well, we're going to transpose that lock, stock and barrel to the intellectually disabled. There are different considerations.
Is that not what happened, though, in this case?
No, not in this case. That's later. That's the Stevens case. Mr. Justice Stevens case.
Yes, Atkins case. Sorry.
Atkins case, yes. And then page 210, Mr. Justice Marshall continues in the same vein. Can I also, in this same judgment, go to the judgment of Mr. Justice Powell at page 220, and he, at page 221 to 223, goes through the various explanations given for not executing the insane. I don't propose to read out these paragraphs, but my lady, if you can just make a note of them. The interesting point is his conclusion. Some of his conclusions. The first point he makes at 222, in the first paragraph, is, I shall come back to this, the first of these justifications has slight merit today. What he's talking about there is that you don't execute the insane man because he might need to be able to make an argument to prevent being executed. You go back to page 221, halfway down the page. Prohibition against executing the insane is justified as a way of preserving his ability to make arguments on his own behalf. Then, page 222, Mr. Justice Powell says, well, that doesn't really make much sense these days when defendants have got proper representation. And in the end, his conclusion at page 223 is that the real reason for the prohibition is that an insane man doesn't know what he's about to face. If he is to be sentenced to death, if the sentence is to be carried out. And page 224, in the second paragraph, is where he makes that point most precisely. Now, in my respectful submission, all these considerations don't really, they might sometimes, but they don't necessarily apply to a man with a low IQ.
So how do you formulate the line?
Well, I say the line stays where, my lord, I say, this is the problem. There has been a rationale which applies perfectly in relation to all insane people. The difficulty is these rationales might occasionally apply to intellectually disabled, but certainly not always. The problem then is, and this is a problem, almost a problem for the common law, the common law simply cannot develop, in my submission, from one clear concept, which with a clear rationale in relation to insane people, and say we're going to draw the line somewhere differently now. How can you? That's the difficulty. And I in support of my submission, I say, well, whereas you can say it's always cruel and unusual punishment to execute the insane in a state of insanity, it's not always cruel and unusual punishment to execute someone who is mentally disabled. It depends on the disability, it depends very much on what they've done. And indeed, the statute itself presupposes that. I mean, the 1985 Act obviously presupposes that there will be some people who are suffering from a mental disability. Nonetheless, it does not sufficiently remove them from the responsibility for the murder.
But
so,
the resolution of that is that you would draw the line at the insane.
my lord, you have it. I say the line must stay where it has been since not for donkey's years, for 3, 4, 5 years.
Notwithstanding your acceptance that in some cases of intellectual disability, of extreme intellectual disability falling short of insanity, many of these factors would apply. You said that the common law is simply incapable of recognizing that glaring anomaly.
Yes. My lord, I say it is not, I say this is just too complicated a matter. Indeed, my lord, I submit there is no common law power to do anything about it. My lord, one of the difficulties with the notion of the common law is that, well, one can develop it. The trouble is sometimes it's not too difficult to see just how one can develop it. In this case raises an acute problem of how to develop it, if it can be developed. And that's one of the reasons why I say it is not something that the courts can develop. The lines have been so clearly drawn in such obviously clear places with clear rationales, it's difficult to see how, realistically, the court can move those lines to where Mr. Fitzgerald wants them to be.
Well, with those firm and clear submissions, we must now adjourn and look forward to hearing from you further at 2:00.